I just have a quick question before we start. I have two amendments to House Bill 1249, one that just says Senator Hennessy and the other which says Senator Feltus and Senator Hennessy. Which one are we going to be using?
Both. So they're not replaced all. Only ones are replaced, and then
okay.
The one built off.
Okay, not a problem. I'll just put them both together.
Senator, the one with just Senator, the one that came in this morning with Senator Feltus and Senator Hennessy's name is both.
Not a problem. Just trying to get a little organized.
In the morning.
All right, so we got YouTube going, and now I'm going to record. I'm going to let the public in, and now I'm going to make Griffin the host. Griffin, can you make me the co-host?
Yep.
You are all set, Senator Hennessy, to go.
Thank you. Welcome. Welcome to the Judiciary Committee. I'm Senator Hennessy from District 5, and I am the chair of the Senate Judiciary. Today, we're going to be hearing a variety of bills from the Judiciary Committee, including HB 1375, HB 1249, HB 687 FN, followed by executive sessions. Before we get started, I will read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of Judiciary, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom software for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and or listen to the meeting on Zoom and YouTube, and via phone by following the directions and links provided on the New Hampshire General Court website. We've provided public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remote Senate, all one word, REMOTESENATE @leg.state.newhampshire.us, or call 603-271-3043. Again, 603-271-3043. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, we will start the meeting by taking a roll call of attendance. And when each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the right to know law. Senator Chandley.
Good morning. This is Shannon Chandley. I am at home in Amherst and I am alone.
Senator LeVake.
Good morning. This is Senator LeVake. I am at my home in Brookline. I am not alone in the home, but I am alone in the room.
Senator Carson.
Good morning. This is Sharon Carson. I am at my home in Londonderry and I am alone.
And Senator French.
And Harold French, live from Webster, New Hampshire, and not alone.
And I am Martha Hennessy. I am in my home in Hanover, New Hampshire, and I'm not alone in the house, but I'm alone in this room. Thank you again for participating in this full judiciary hearing this morning. We will have many speakers today, and we recognize that there will be passion on both sides of these important issues. First, I want to be sure that the procedures are clear in this new way of meeting. Today, our host, Griffin, will be calling all individuals who have signed up. If you did not sign up, you can do so on the general court webpage by raising your hand virtually. If you are calling in, you can raise your hand by pressing *9. If you're having any problems, again, feel free to contact us or the staff via remote senate at ledge, L-E-G, in other words, .state.nh.us. We want to hear from everyone who wishes to speak. In order to fulfill this obligation, we will need to limit everyone's testimony to 3 minutes, which has become customary in Senate Judiciary. When your 3 minutes have expired, you will hear Cam come on to tell you that your time is up. Please finish your sentence and then finish right away. One exception to the 3-minute rule is the prime sponsor. I also ask the prime sponsor to limit their testimony as much as reasonable also, to ensure that we can hear from everyone who has signed up to speak. If you have written testimony that you have not yet submitted, please do so as soon as possible. We're expecting a very long hearing today with many people having signed up, and we thank you in advance for following the rules as presented. I'm going to give you just a few tips. Some of you heard this already, but a few tips to remember while testifying. First of all, please summarize the key points of your testimony. Please do not repeat what has already been said. Instead, make your testimony unique by telling it from your perspective. Some of the most powerful, memorable testimony is brief and uniquely personal. And so we are now going to go into the hearing. And I would like to start by recognizing the prime sponsor of HB 1375, Representative Hunt.
I do not see Representative John Hunt signed up to speak, but if he is attending, I ask that he virtually raise his hand. If you're on the phone, Representative Hunt, please press *9. Not seeing him. Obviously, he can raise his hand later, but we'll move on to our next speaker, Representative.
Would you like me to introduce it?
Yeah, sure.
I will just read the title of HB 1375, which is an act relative to cancellations of commercial insurance policies.
Our next speaker I have is Representative Cushing. Give me just one moment.
Here he is.
Am I unmuted?
Yep.
Oh, good morning. Thank you, Madam Chair, members of the committee. For the record, I'm Representative Rennie Cushing, Rockingham District 21. I'm actually here primarily to speak in support of the amendment to establish a medical monitoring law in the state. So with that, thank you. I'll speak to the amendment.
Hey.
Moving on to our next speaker I have is Joseph DiPaolo. Here.
And just a reminder that we are now speaking to HB 1375.
I do not see Joseph DiPaolo signed up to speak, but if he is here, I ask that he raise his hand and we'll come back to him. Next person I have is Howard Harris. And I apologize, I do not see him signed up to speak either. If he is present, please raise your hand. Moving down the list, I have Daniel Stewart. Daniel, if you're present, please raise your hand. All right, it's going well. Moving on down, let's see. Brad Rodenberg. I apologize if I butchered your name. One moment.
I see somebody.
1 second. Oh, yep, hold on. Brad?
Thank you. I'll keep it short and sweet. All I could think of when I read this was what my ex-wife would have done with it when we were going through our divorce. The potential for abuse is what alarms me.
So Mr. Rodenberg, are you speaking to House Bill 1375?
Yes, ma'am, the red flag.
That is actually not the red flag. We'll be coming to that later in the morning.
My apologies.
Okay, thank you.
Moving down the list, I have Gregory Smith. Moment.
It's possible that many of these were intending to speak to the amendment.
Gregory, are you there?
Yes, I am. Can you hear me?
Yep.
Oh, thank you. Well, I wanted to speak to the amendment, if I may.
Oh, all right. I'll come back to you on the amendment then. Let's see. Our next person to speak on House Bill 1375 is James Cross. James, are you there?
Yes, I'm here. Can you hear me?
Yep, we can hear you.
I was speaking to the amendment as well. I don't know what the problem is, but I only wanted to speak on the amendment.
Okay, we will come back to you on that one as well. All right. Moving on down. Our next person that we have signed up to speak on House Bill 1375 is Ken Ramelt. Oh, disable. Ken, go ahead.
Hi, my name is Ken Rumelt. I'm a professor of law and senior attorney at Vermont Law School. And I wanted to offer my support for HB 1375. I've been working on the issue of medical monitoring for a number of years, dating back to my early days as a young attorney in Missouri. And it's a critical aspect of the law that has developed over the years.
I'm sorry to interrupt you, Mr. I'm really sorry to interrupt you, but because we do definitely want to hear from you, but I think you may be speaking to the amendment as opposed to the bill. This is confusing this morning.
Okay. The amendment that I have in front of me is claims for medical monitoring.
Right. And we're going to be speaking to that. We're going to be speaking to that in just a minute. Right now, we're just asking for anyone who wants to talk to the original bill, which is HB 1375. And the title of that is Cancellations of Commercial Insurance Policies.
Oh, okay.
It's confusing. I apologize.
All right. We will come back to Ken on the amendment. Looking through the list, and just to be clear, this is on House Bill 1375, the bill, not the amendment to House Bill 1375. I do not see any other people signed up to speak. If there is anybody who wishes to speak on House Bill 1375, the bill, not the amendment, please raise your hand. At this time, I don't see any other hands, Senator Hennessy.
Thank you. So we will be now opening the hearing on Amendment 15. We will be closed. Do we have to close it first? Yes, we will. I'm sorry. We will close the hearing on HB 1375. And at this point, we will open the hearing on Amendment 1548S and ask for Senator Chanley to introduce the amendment, reading the title and explaining the content.
Bless you.
Excuse me, sorry.
Bless you. Thank you very much, Madam Chair. This is Shannon Chandley. I represent District 11 in the New Hampshire Senate. and I am here to introduce Amendment 1548, I believe is the correct number. And I'm sorry, I'm going to go back this way. So this is very similar to a bill that I had introduced in the Senate. This amendment is essentially the content of what was HB 661. The bill that was very similar to the one I had introduced in the Senate was worked on by a really fantastic subcommittee in the House. And I think that everyone has, I hope that folks have seen Representative McLean's testimony that came forward. And what essentially this does is put into law what is currently common law practice in a standard that allows for people who have been harmed by toxins to have monitoring done at the expense of the person or entity that has harmed them over time. Because often when people are harmed by a toxin, the resulting injury is not immediately detected, but the toxin may well be detected. And there are quite a number of people who can speak to the legal structure around this much more effectively than I can. And I really do hope that we hear from folks from the subcommittee, because I think that they had many sessions, and I think the work that they have produced is excellent. So with that, I'd like to say thank you very much for consideration of this amendment.
And now Griffin will be.
Madam Chair, I have a question for Senator Chandley.
Oh, thank you. I'm sorry. Yes, go ahead.
Good morning, Senator Chandley. I have just a quick question. We live in a very mobile society and people do move around quite a bit. How do you account for someone who might have gotten exposed to something here in New Hampshire and then say they've moved away, say they've moved out to the West Coast or they've moved down to Florida? How is medical monitoring going to work in that instance?
Okay, thank you. Thank you for that question. I certainly think that a person who is, let's say for the purposes of your example, if a person is harmed by a entity in New Hampshire, the person could bring suit in New Hampshire despite where that person currently lives. Now, again, I think that is a question that a lawyer could answer much better than I can, but that would be my certainly my presumption.
May I follow up, Madam Chair?
Yes, please.
Thank you. I'm more concerned when you talk about medical monitoring, and it looks like from reading the legislation that you're going to be doing something like that for the term of a person's life. And that's why I brought up the point that many people will move around. And especially if you have a child that has been exposed to something, how are you going to be able to monitor them if they move out of the state of New Hampshire? Who's going to be financially responsible? Who's going to pay for that lifelong monitoring? Do you envision that someone getting a lump sum payment through a judgment and they will have to pay for it on their own? Or is the responsible party going to be responsible for payment of lifelong monitoring as they go through their life? I'm just really not sure how this is going to work.
Well, thank you very much, Senator, for the question. I believe that this is exactly why the the case would be determined by the court. What, the court will assess what a reasonable approach to that monitoring is. And it would most likely be, as the legislation says, necessary and periodic examinations. And those costs will be borne by the entity that found responsible. It is possible, and I think the legislation allows for relief to be awarded at the outset, but that would be kept in a court supervised program, and it would not be something people would not, according to this legislation, necessarily receive some kind of lump sum, as I believe you mentioned. It would rather be done in a way that allows for that money to be spent for the specific purpose of monitoring.
May I follow up, Madam Chair?
Follow up?
Thank you. I can see on page 2 of the amendment, lines 8 and 9, that it says may. I'm just wondering, and there's a lot of may in here, that if it would be more appropriate for stronger language, that rather than letting the court make the determination, that the legislature would be the ones really saying, look, if you're found guilty, you shall do this, 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 and this. So, but I mean, that is, I guess another matter. So, all right. Well, thank you very much, Senator. I appreciate your answering my questions.
You're welcome. And I would say that may, again, is a way of us allowing for the determination to be made by the court specific to the circumstances under which the issue is being addressed. Thank you very much.
Are there other questions for Senator Chamley?
Madam Chair, I don't have a question. I'd just like to point out a typo on line 12. It says medical monitoring claims shall be made with 3 years of the effective date. I think it should say shall be made within 3 years of the effective date. So we might just need to get a committee amendment to correct that.
Thank you. You have that, Jenny.
I mean, we can absolutely make a committee amendment, but I think that would be something that would probably, we could request OLS pick up in enrolling. But it's up to the determination of the committee.
Sounds good. Thank you. Seeing no other questions, we'll go ahead and call people.
Our next speaker is Representative Cushing. And again, this is on the amendment to House Bill 1375.
Thank you very much, Griffin. For the record, I'm Representative Rennie Cushing from Rockingham District 21, and I'm here in support of the Shandley Amendment, which in the House and Judiciary was the Wolper-McLean Amendment that came from the subcommittee of the House Judiciary Committee that worked for a year, met 6 times, and involved a number of stakeholders to come up with the language of 661, which is now in the amendment that's before the committee. I first became aware, and I also would state for the record, I was a prime sponsor for House Bill 661, which is embodied in this amendment. I became aware of the whole concept of medical monitoring when I served on the Seacoast Cancer Cluster Task Force, because we had situations arising in the Seacoast where we had a cancer cluster, and there was almost a inordinate number of rare pediatric cancers. There was a situation where families who had children in a daycare center came to find out that the water that was in the daycare center contained PFAS far in excess of that which would be healthy for anyone, and wanted to have access to medical monitoring of their children. And as it turned out, that in the instance of the exposure at Pease, in a number of instances, that was granted. But for a lot of families who have had a situation where a loved one or individuals where a loved one has been exposed to a proven hazardous or toxic substance by someone negligently, there is a need to make sure that they have access to the ability to monitor the health on an ongoing basis so that there can be a time for an appropriate intervention. And that's what this House Bill 611, or that's what this amendment intends to do. I won't go over the ground that's covered under the memo by Representative McLean, but I think it does kind of, it captures this long journey that people have been on. And I've been very impressed by the diligence and the thoughtfulness that went into this, the amendment. And I would urge the committee to pass it as is. I can respond a little bit to Senator Carson's question. And what this law does, it provides a framework that's more streamlined and more focused, that's a little bit more focused than what the common law tort action is, by which a judge and a jury, but when it's the court itself, can make an individual determination based upon the specific facts of a specific instance of exposure, and given the science involved in that, what is an appropriate remedy that will provide for medical monitoring. And I know that in other jurisdictions, there are ways such as the establishment of a court-administered trust fund. It's like any other, tortious act. It's any other.
Interrupt, Senator Hennessy. That's been 3 minutes.
Okay. Then I appreciate that. I will sum up, and I know that there are others who will speak after me, but I would just urge the Judiciary Committee to act favorably upon this amendment as presented. And I'll be willing to answer any questions that people have.
Thank you very much, Representative. Are there any questions for Representative Cushing? Seeing none, go on.
The next speaker I have signed up is Representative Mark McLean. However, I am not seeing his name on the list. Representative, if you are present, I ask that you please raise your hand and we will come back to you. Our next speaker is Representative Wendy Chase. Representative?
Hi. Can you hear me?
Yep.
Okay. I didn't realize I had signed up. My name is Wendy Chase, representative for Stratford County District 18. And I was on the subcommittee for this bill. I also grew up in Hampton and recently lost my daughter to a childhood cancer. So this is very heartfelt to me. It's a very important bill. I'd like to see if there's possibly any answers, but when it hits home like that, it's very important. We did a lot of work in this subcommittee. We scrutinized a lot of things. The bill itself, I felt, was a wonderful bill, but it lacked some clarification, which was brought up earlier with the senator. I like the amendment very much. I think it's really answers a lot of the questions that we had dug in depth with. And really, I just hope that you consider this is such an important issue. Me as a mom, I have no idea if my daughter's cancer was related to the water that I drank my entire life, but it created chaos in our family. As I said, I lost my daughter after 32 years of battle. And it's just extremely important. And the financial burden that was put on the family is just something that should be able to be covered if this does come out that it's found it is something that's been done to the water. these families that even with the moving around as said that had been set up, that it would be either given in a bulk payment or the other thing is just being able to monitor the progression of a patient. God, hoping that they get better. If they don't, at least we can monitor this and see what are the repercussions of the disease, how far does it affect a person's body, and just really being able to keep track of the cluster and hopefully the downside of it. So I want to thank you very much for letting me speak. And also, please, 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 I hope that you will consider this amendment. Thank you so much. Stay safe.
Thank you. Are there any questions for the representative? I see none.
Thank you.
Our next speaker I have signed up to speak is Representative Marjorie Smith. Give me one moment.
I just got a message from Representative Smith saying that she would not be able to be here. Oh, she
no.
there? Oh, there she is.
Here I am.
Great.
It was worth the struggle, Madam Chair, to
excellent. We're glad.
And it was a struggle. As chair of the House Judiciary Committee, in these uncertain times, I provided a very, very short list of priority bills to Senator Hennessy, and all of the other priority bills did not make the Senate cut, but this one did, and it should have. It is, I don't want any praise for the fact that the Judiciary Committee spent an inordinate amount of time on this, because we try to do that on all our bills. But we have an expanding understanding in the world we live in of the long-term negative health effects of toxic exposure. The bill that came to us identified a very important area, and it was very, very broad. And we spent a lot of time trying to narrow the focus, to provide guidance relative to the rights and responsibilities of all the parties involved in a monitoring claim. And we struck a balance with all of the disparate interests here. We based the legal standard on the growing body of case law in the area. We, with reference to Senator Carson's concern, we preserved the need to show negligence and causation on the part of the defendant, and we required the plaintiff to demonstrate an increased health risk from significant exposure that requires the monitoring. The final amended bill holds negligent chemical users accountable, protects the users who operate in good faith and compliance with the law, and provides a much needed legal remedy for monitoring to those who are exposed. The committee voted 16-3 in favor of this amendment, and the strong bipartisan support, I hope, was enough to carry it across the wall, so that you will be able to look at this and recognize the value of this carefully balanced amendment. Thank you very much, Madam Chair.
Thank you, Representative Smith, and for all the work that you put into this. We are very happy to see that it made it through. Are there questions for Representative Smith? I don't see any. Thank you. I'm glad you were able to get on.
Thank you.
I would just like to make one comment. I got a message from the majority leader saying that he would just like to say that he would like to sign on in support, but he's unable to be there for this amendment. Thank you.
You got him.
Our next speaker, I don't see him registered to speak, but I've heard he may be available. Senator Tom Sherman. I do not see Senator Sherman present in the call. If he would like to raise his hand and let us know that he's here. We'll come back to him. Our next speaker would be Ken Ramelt. And again, this is on the amendment to House Bill 1375.
Hi.
Welcome back.
Thank you. So this is Ken Ramelt again. I'm a professor of law at the Vermont Law School. And as I mentioned before, I've been working on medical monitoring related issues for some time now. And as we've heard from others who testified before me, the ability to recover medical monitoring and after being exposed to a toxic substance is an important remedy. It's one that a number of jurisdictions have adopted, and as a prior the person mentioned, there's a growing body of support in the case law for medical monitoring. And specifically, this bill is really hits at the touchstone of medical monitoring, which is that it does not require proof of present physical injury or symptoms. Okay, that's really the key to medical monitoring, because the entire point is that you're trying to discover latent disease as early as possible. We've all heard the phrase, an ounce of prevention is worth a pound of cure. Well, in the jurisdictions that have not allowed medical monitoring claims to go forward, it's because they require a present physical injury in order for a claim to be brought. And so what you're talking about is essentially saying, you have to show me that you have the disease in order to bring a claim for monitoring. Well, once again, that defeats the purpose of monitoring if you already know you have it. And I think, as to the rest of the bill, it hits on all of the major elements that the leading case law addresses, including need for diagnostic testing, increased risk of illness, and it allows the courts to place an award into a program that's administered by the court and medical professionals. So it's a strong bill, it's a good bill, and I would urge its passage.
Thank you, Mr. Ramelt. And are there questions? I do not see any. Thank you for being here.
Okay, thank you. Our next speaker that we have signed up is Representative Wendy Thomas. Okay.
I represent the town of Merrimack, and I'm one of the original water warriors. The town of Merrimack appreciates and supports this amendment. Our town has been contaminated with PFAS for years by a local business. We have a right to know how many of these toxins are in our bodies. It is documented that Merrimack has increased illness and cancers in our town. Many families, mine included, are living on bottled water because our well water is too toxic to drink. Medical monitoring allows us to be proactive. For example, PFAS is tied to breast cancer. If my daughters know that they have high levels in their blood, they can now take charge of their health and have more tests or pursue preventive care. The benefits of medical monitoring are immense, and I fully support this amendment. Thank you.
Thank you, Representative. Are there questions? Seeing none. Thank you for being here.
Let's see. Our next speaker, former Representative Mindy Mesmer. Give me just 1 second.
Hello, can you hear me?
Yep.
Yep,
Thank you
welcome.
very much. Thank you very much for hearing this important amendment today. For the record, I'm Mindy Mesmer, an environmental and public health scientist from the seacoast of New Hampshire, and Rye, former state representative for Rye and Newcastle. I support this amendment wholeheartedly. I, as Representative Cushing mentioned, first became involved in the situation in 2016 when the task force was formed by then Governor Maggie Hassan to investigate the high rates of pediatric cancers on the seacoast in the cancer cluster area. I heard first from the mothers of the children who had been exposed to high levels of PFAS chemicals in their water unknowingly when they sent them to daycare every day, and then were faced with the possibility that their children would become sick. And to this day, many of those people still have not been able to get their children monitored for the effects of that exposure. So this is something very near and dear to my heart. I first submitted this kind of legislation in 2018 as a state rep. So the House Judiciary Committee has worked on this for several years, and I'm very thankful to their hard work, and the product that has come out of their committee is very important to the people of the seacoast, but also to the people of the Merrimack, Bedford, Litchfield area, where to this day, 190 PFAS chemicals are being emitted from Saint-Gobain stacks every single day, contaminating the air and the water of that area above levels which we know are safe for people to drink. So this is a very important bill for many of the people of the state of New Hampshire, where we have exceedingly high rates of cancer across the state. Our children are getting cancer at the highest rates in the country, as well as the highest rates of bladder, breast, and esophageal cancer in the nation. And we need to do what we can do to prevent people from getting sick. So this bill amendment actually is intended to provide monitoring so that we can possibly catch some of these chronic diseases and cancers before they become stage 4 cancer and take the lives of so many more people in the state of New Hampshire. So I ask that the committee seriously consider passing this amendment as is. I've submitted written testimony this morning to the committee as well, and I hope you take that into consideration when you vote on this bill. Thank you so much for your time, and would be open to any questions if the chair wishes to have them.
Thank you very much, and thanks for being here. Are there questions? Seeing none. Thank you.
Our next speaker I have signed up is Joseph DiPaolo, but I am not seeing his name in the attendee list. Joseph, if you wish to comment on the amendment to House Bill 1375, please raise your hand and we will come back to you. Our next speaker I have listed to speak on the amendment to House Bill 1375 is Gregory Smith.
Can you hear me?
Yep.
Yes,
oh, thank you. My name is Gregory Smith. I'm a partner at the McLean Middleton law firm in Concord. I am here today representing Waste Management of New Hampshire. It's my understanding that this bill has been generated by the concerns about PFAS in New Hampshire, and I am not here to speak about that. The problem in this legislation that I would like to specifically address is that it sweeps thousands of New Hampshire businesses who don't handle PFAS into a statutory scheme which is different from anything that we've had before and treats those businesses unfairly. And I think it is in combination. I realize there are a number of provisions that the legislators have developed and support strongly, but in the combination of all of them, it is different from any other provision that I'm aware of in the United States. So I proposed an amendment that I tried to submit to you last night, making a modification to strike on page 2, lines 2 and 3, physical injury, and leaving the word symptoms, so that anyone who's going to make a claim would have to show, even if it's at a cellular level, at a microscopic level, there's some evidence that their body has been injured. Otherwise, what the bill does is allow the diversion of resources to people who have not been injured, have not shown that they've been injured, may never be injured, and away from people who may well be injured. So I think it would be better to make that change. Why do I say it's unfair? Because I think it's plainly so, because parties in cases like this are foreclosed from presenting highly relevant medical information for the court to consider in a medical monitoring case. That provision appears in the section right below the one I referenced on page 2, lines 4 and 5. And I see no reason why the court shouldn't be able to consider that evidence. What all parties should want is a just result. And justice requires that the parties have a fair, full hearing. What the bill does in respect to these two provisions I've pointed to is restrict the usual approach in hearing a case like this. Let the court hear the evidence, and then let the court make a fair and a just a determination in each case. So with that, that's mindful of your schedule. I'm completed my remarks, Madam Chairman.
Thank you. Thank you for being here. Are there questions for Mr. Smith? Senator French.
Thank you, Madam Chair. Thank you, Mr. Smith. You still with us?
Yes, I am. Thank you.
So I wanted to take positive action on this problem we have, yet I was worried about what you were talking about, widespread instead of more focused address this problem. So are you telling the committee that if we just simply remove physical injury, or that it would take care of and address those issues I have?
I think that it would address them. I think it would help if you took the other provision out, but I didn't mark the bill that way that I mentioned. But to this point in the strikeout that I gave you, there is recent case law, as recently as April of this year, where courts have recognized that PFAS claims won't have difficulty on this point, because PFAS is present in the bloodstream of virtually every American citizen. So they can show that they have been exposed to it, and there's evidence in their body that they have PFAS. So taking out the provision about that I've proposed would help in all the other kinds of cases, all the other businesses involved in completely different activity using all kinds of other substances. There should be some proof of physical injury as well as exposure to those chemicals. So that's why I say I'm not speaking this morning about the PFAS issues. And I'm not speaking on behalf of anyone on those issues. I'm speaking about the effect on other businesses for all other chemicals. And I think the bill would be unfair to them by these provisions that I pointed to.
Great, thank you.
Senator Chanley.
Thank you very much, Madam Chair. Thank you so much for your testimony. I appreciate your suggestion. I'm trying to understand, though, two things. First, my first question is, was this amendment ever considered by the subcommittee in the House, if they considered it and rejected it, or obviously they did not include it? And my second question really has to do with trying to understand how removing the language that you want to take out, or taking that language out, would suggest to me that monitoring wouldn't, if physical injury is existent, then what would the necessary, why would we need proof? If I guess I hope I'm trying to ask this correctly, but the whole point of monitoring is to see what happens as a result of the exposure to the toxin. And if we say that proof of physical injury is necessary, then that seems to defeat the purpose of monitoring to me. And maybe I'm misunderstanding you. So those are the questions.
No, I appreciate that. Those are thoughtful questions, I think. There were a series of things discussed previously I think this is probably one of several. Now, in my view, I'm only down to these. And in the law, which is developing all across the United States, in order to bring a claim against someone else and make them pay you, you have to show that somehow there was an injury. But that law has developed with modern science to a very subtle level. So I left in the language about symptoms. It's not necessary to show any symptoms, but there ought to be some evidence, even if it's at the molecular or cellular level, some evidence given our subtle science these days that you actually have been affected by these substances. May not have any diseases yet, may not have any symptoms yet. This bill would provide relief anyway, but there should be some evidence that you had some physical injury. That's been American tort law forever. And so I think taking that out is unfair to, and I'm speaking about all the other businesses. And this would be different in combination with all the other provisions in the bill, so different that I think you'll find people coming to New Hampshire to litigate these cases because they can't litigate quite this way anyplace else, as far as I know. So I'm really trying to promote a fair and just process for the parties in these cases. And I think that while everybody's been focused on PFAS, they haven't realized how broad and sweeping this would be for all other businesses to make a change of this type. And the point I was trying to make is, if you make this change, it won't disadvantage the PFAS claimants, as far as I can see, because as I said, court cases have come down as recently as April saying people have no difficulty showing that because every one of us has PFAS in our bloodstream. They can show they've been affected by PFAS. This would, so having to show some physical proof, they could show in every case. But that wouldn't necessarily be the case for all these other thousands of businesses and thousands of other substances. And I think that's a problem. I think it would be very unfair to the business community, and it would tend to divert resources to people, as I said, who have can show no injury in these other cases, may never have any injury or any illness, away from people who may actually have an injury for one reason or another. That's why the policy is questionable in my view.
Thank you very much.
Are there further questions? Seeing none. Thank you for being here, Mr. Smith.
Thank you. Thank you very much for hearing me.
The next speaker we have is, and I apologize because I'm going to mess up this last name, Tom Bloomquist. I hope I'm saying that correctly.
Good morning, ladies and gentlemen. I actually signed up to speak on HB 687.
Okay.
Is that what this committee is dealing with?
No, we are dealing with the amendment to House Bill 1375 right now. I believe House Bill 687 will be later today. If it's all right, we'll chalk you up on, or we'll get you on that bill when we get to that hearing, if that's okay.
Thank you very much for your time.
Thank you.
Let's see. Our next speaker I have on the amendment to House Bill 1375 is Laura Hopkinton.
Welcome.
Thank you so much. Laura Hopkinson of Meredith, New Hampshire, just a resident and citizen here, no official capacity. I too am interested in 687, but thank you for acknowledging me. I'll go ahead and hold until the next conversation.
Okay. And our last speaker signed up to speak on Amendment House Bill 1375 is Anthony. I'm not even going to try it because I know I'm going to screw it up. Give me just 1 second to find it.
There he is.
Anthony, can you hear us?
Yes.
Yep, go ahead.
Good morning, Senators. My name is Anthony Scullambrini. I'm a lawyer in Nashua. I just wanted to give you some information about how these cases work. First, I'm in support of the amendment as it's written. Senator Carson had a good question about what happens when people move around. One of the things that has happened over the past 30 years in the law is that the federal courts have taken the lead on a lot of these cases. And so what ends up happening is cases from all over the country get consolidated. So the federal court in Concord, for example, has vaginal mesh cases as part of a multi-district litigation. And they're from all over the country, California, Kansas, all over the place. And they have managed to be able to track up to 40,000. I think they had 40,000 people in the largest case from all over the country. And they're able to track them and provide them with the care that's necessary should the cases be resolved. It's not that much different than what would happen if you used your insurance from New Hampshire to get medical care in another state. As long as you're paying attention, as long as the federal court's sending out notices, which they will, then you should be okay. So moving around is not an impediment. I wanted to address a couple of things that Mr. Smith said. First of all, removing the proof of physical injury requirement would basically be a Trojan horse allowing defense attorneys in cases like this to import bad language from other states. And the problem here is that if you look at why these cases came about, it's because people were exposed to a known harm, but the consequences aren't immediate. And Friends for All Children, a plane full of Southwest Asian children was depressurized at altitude. And because they were too little to know whether or not there was any brain damage, the court ordered that they be monitored. And this is a similar situation with the chemicals that people are exposed to today. We don't know what the consequences are. And to not have them monitored seems to be an especially cruel thing. The other thing that I wanted to point out is Mr. Smith said that he wants to let the courts hear the evidence. But generally, the motions that are filed when the proof of physical injury language is removed are filed at the beginning of the case. If you're familiar with federal litigation, it's done pursuant to Federal Rule of Criminal or Civil Procedure 12b-6, and those happen to have to be filed within the first 21 days in a case, and that's before discovery is done and before evidence is presented. So it is not the case that removing this language will allow the courts to hear the evidence. And finally, the point about monitoring is that science is always behind the curve because new chemicals are always being made and the sensitivity to the body to these new chemicals is being refined. And so if we don't allow monitoring, we're going to be chasing sick people as opposed to preventing people from getting sick. And so for those reasons, I'm in support of the amendment.
Thank you very much. Are there any questions from the senators? Seeing none, we appreciate your being here, Mr. Scullenby. Can't hear you, Griffin.
There we go. That concludes the list of people I have signed up to speak on the amendment to House Bill 1375. I did have one or two hands raised from people who I believe wish to speak to the amendment. Representative Alt-Schiller has her hand up. I'll bring her in a moment.
Can you hear me?
Yep.
Good morning.
Excellent. Good morning. Thank you very much for allowing me to speak. I actually worked on that summer subcommittee and tackled a lot of the issues that we're hearing about today. And I wanted to just dial back around for the committee to consider that the reason we were considering this in the first place is that we have upwards of thousands of New Hampshire residents who have been exposed to chemicals and toxic substances that may or may not show up, as one of the people who was testifying earlier said, on a cellular level. I represent my district of Stratham in District 19 on the Seacoast, is part of the community of 10,000 people that work at the Pease Trade Port in Portsmouth. And there is a daycare on the Pease Trade Port. In fact, there's a number of them, but the largest of which is Great Bay Kids Company. And within my own neighborhood, I have children who were at Great Bay Kids Company and were exposed to PFAS for a significant amount of time before that well was shut down and the PFAS was discovered. And what we don't know is whether those babies whose formula was being mixed with that water, or those toddlers whose juice was being cut with that water, or anyone, those kids or the workers at that daycare facility who were drinking that water and washing children in that water, will have a learning disability later on. We do know that there is a tie to learning disabilities and later on in life, but we don't know. We know that there's an increase in cancer, perhaps, that's been linked to PFAS, but we don't know how early that develops. And one of the reasons we need this medical monitoring is for people right here on the seacoast, particularly for me on the seacoast, but also over in the Merrimack area, for these thousands of people who have been exposed and through no fault of their own, now need to keep a special eye on their own health so that they're learning, their reproductive systems and their immune systems are watched, unlike somebody who grows up in another part of our state and is not exposed to these kind of chemicals. So I thank you very much for considering this amendment. We worked really hard on this over the summer in the House, and I really appreciate you taking it under consideration.
Thank you for being here. Does anyone have a question for Representative Altschuler?
I have a question. Do I mute me or do you?
I believe Griffin will.
Perfect. Thank you.
Thank you very much.
All right. Our last person that we have wanting to speak is Representative Horgan with his hand raised. If anybody else would like to speak on the amendment to House Bill 1375, please raise your hand.
Good morning, Representative Horgan.
Oh, good morning, Senator Hennessy. I thought I heard my name called earlier while I was going to get a cup of coffee. But anyway, the question was raised way back at the beginning of the hearing about what happens if the, I guess, plaintiff moves out of state. That doesn't affect the status of the lawsuit. This is medical monitoring is something that's going to kick in, in the context of a successful lawsuit against the polluters. And I can see why polluters don't want to pay for the damage they cause, but it's a simple matter of fairness. They should pay, and the medical monitoring is a tool that we can use to see if somebody has been damaged, whether it's which is usually by drinking water, and pollution of drinking water is something that's on the public's mind. It may not get much attention in the press or here in the legislature, but that's something I think all of my constituents, everyone statewide and nationwide, is extremely worried about. And this medical monitoring is just a simple thing. I think it's just a very simple thing. It doesn't actually cost very much unless the person turns out to actually be sick, and then the polluter has to pay, for the cost of the medical care, which I know that can be expensive, but that's perfectly fine with me. They should pay. So that's and I was not on the subcommittee, but I am on the standing committee the subcommittee was part of, and we all worked very hard, and we have a very wide range of opinions on everything, but we managed to get almost unanimous agreement on this in the committee and also in the House, which, as especially most of you on the committee have served there, it's we have a lot of wide variety of opinions in the House too. So I urge you to pass this bill, and we can get it onto the governor's desk, and we can get it signed. And thank you.
Thank you, Representative Horgan. Any questions? Seeing none, thank you for being here.
I don't see any other hands from anybody wishing to testify on the amendment to House Bill 1375. I think that concludes the list of people interested to speak.
Thank you very much. At this time, we will close the hearing on the Amendment 1548S. And we will begin by opening the hearing on HB 1249 and call on the prime sponsor, Representative Berrien.
I do not see Representative Skip Barron signed up to speak. Representative, if you are calling in, I ask that you raise your hand by pressing *9. I do not see him, Senator Hennessy. I know if maybe you'd like to introduce the bill on his behalf.
Thank you. I will do that. I'd like to introduce House Bill 1249 relative to the legal representation of children in the juvenile justice system. This bill provides for the appointment of counsel for children in out-of-home placements under RSA 169B and RSA 169D.
Let's see. The next person I had signed up to speak was Representative Altschiller on House Bill 1249. Give me 1 second here. Representative?
Welcome back.
It appears she's still muted. Representative, if you could unmute yourself, and if you'd like to testify on this bill, please raise your hand and we will come back to you. Our next person that we have interested to speak on House Bill 1249 is Michelle Level. And I do not see Michelle signed up as an attendee here. If she's calling in by phone, please dial *9 to raise your hand and we'll come back to you. Next person I had signed up to speak is Wesley Sullivan, I believe. And I do not see him signed up to speak on this either. If he is interested to speak or calling in by phone, please raise your hand by dialing *9. We will come back to you. Our next speaker on this bill would be Daniel Stewart. And I do not see Daniel Stewart signed up to speak on this bill either. Mr. Stewart, if you'd like to speak, I ask that you please raise your hand and we will come back to you. Let's see. Next speaker I have is Travis Williams. And again, this is on House Bill 1249. And I do not see Travis Williams signed up to speak on this bill either. Travis, if you are calling in by phone, please raise your hand virtually by pressing *9. Our next person that we have is Virginia Sheehan. Oh. Virginia?
Welcome.
Virginia, you should unmute yourself on your end.
Hi, can you hear me?
Yes.
Yes.
Sorry about the noise in the background. I am testifying on the amendment to this bill. So would you like to hear from me later? Or that Senator Feltus is going to introduce an amendment or?
So yes, if you don't mind speaking later when we're talking about the amendment, that would be great.
Okay, thank you very much.
Yep.
Let's see. Our next speaker is Donald. I'll bring Donald in. Donald?
I'm in the same status as Attorney Sheehan. Speaking
Okay.
later, thanks.
Speaking on the amendment. All right. Let's see. Let's see. Our next person speaking on House Bill 1249, I have is Jonathan Caldwell. And I do not see Jonathan Caldwell in the attendee list. Jonathan, if you'd be interested in speaking on this bill, please raise your hand. We'll come back to you. Our next one, Carol Gullah, if she's available. Carol, are you there?
I see her name.
Carol, can you unmute yourself on your end if you'd be interested to speaking on House Bill 1249? I'm not getting her. So Carol, if you'd be interested in speaking, raise your hand and we'll come back to you. Let's see. Our last speaker who is signed up in support and speaking on this bill, I have is Mary Crook. And I do not see Mary Crook signed up to speak on this bill either. Mary, if you'd be interested to speak, please raise your hand. Other than that, Senator, I have nobody else to speak on this bill.
Okay, thank you. So we will close the hearing on.
Oh, I'm sorry. I'm very sorry. Representative Altschiller just shot her hand up. I'll bring her in. Representative?
Yeah, can you hear me?
Yes.
Okay, great. I recognize a series of names that you just called, and I think they are erroneously put into House Bill 1249 and should be in 687.
Okay.
Thank you.
All right, thanks.
Okay. So if there is no one else wishing to speak, nope, we will close the hearing on House Bill 1249. And we will open the hearing on Amendment 1550. And I will read to you that I'm going to introduce the Amendment 1550 to House Bill 1249. This is an act relative to the Commission on the Interdisciplinary Primary Care Workforce and relative to multi-county grand juries. So this includes two separate issues. And the first one is essentially the extension of a commission, just slightly changing what is happening in the commission, but mainly changing the name of it and to include the interdisciplinary primary care workforce, and also extending the date until 2024. The second part of this, which for those who have the bill is on page 3, is the multi-county grand juries convened by the Superior Court. This was requested by Judge Nato, and it's the first thing is that it's an order convening a multi-county grand jury pursuant to RSA 600B1, and that all matters to be included in such order shall be determined in any manner with the Chief Justice of the Superior Court deeming it appropriate, except that the Supreme Court may adopt general rules consistent with the provisions of this chapter establishing standard procedures for the convening of a multi-county grand jury. So that is what we will be hearing on in the amendment 1550, which was an amendment of House Bill 1249.
Very well. I will call our first speaker on the amendment to House Bill 1249. I have Michael Icapino. I hope I'm saying that last name correctly.
Good morning.
Good morning.
Can you hear me?
Yes.
Yes.
Thank you. My name is Michael Icapino. I am a lawyer in Manchester, New Hampshire, and I am authorized to testify against this amendment to your committee today by the New Hampshire Association of Criminal Defense Lawyers. The New Hampshire Association of Criminal Defense Lawyers is a body of approximately 300 lawyers who at least have as some part of their practice criminal defense here in the state of New Hampshire. I've been a lawyer for 36 years. I've been a criminal defense lawyer for 36 years. We oppose this bill for a number of reasons, or this amendment to this bill for a number of reasons. I recognize that it is a well-intentioned bill. I recognize that it is designed to deal, that it's temporary in nature, and that it is designed to deal with the current virus emergency. However, it's our position that this amendment would create a process that undermines the important core principles of the grand jury. I'm sure you'll probably hear from some folks that, the words grand jury are not in our Constitution at all. And that's correct. You won't find them there. You find them in the federal Constitution, but not in our state Constitution. There's a reason for that. And the reason for that is that the concept of a body of citizens that is charged with both bringing charges and protecting people goes back hundreds of years before our state constitution was even conceived of. The concept of the grand jury runs back to 1215 at Runnymede, where the Magna Carta was issued. So it's an important, the grand jury has an important role. It's an important concept. It is pre-constitutional. And it is something that we respectfully suggest to you should not be tampered with an amendment like this. The primary purpose of the grand jury is to bring charges, but the flip side of that coin is that the grand jury also protects innocent people who may be accused. When you take the grand jury and you leave the local community with it, you minimize and you diminish that protection that the grand jury provides to the falsely accused. I'll give you two examples. I did file written testimony and they're in there as well. But I'll give you two examples to speak of. The first is obscenity prosecutions. You may know that in order to prove that material is obscene in an obscenity prosecution, the prosecutor has the burden of demonstrating that it violates notions of community decency.
I'm sorry to interrupt, Senator Hennessy. That's been 3 minutes.
Thank you very much. Would you like to finish that sentence?
Sure. When you remove this ability and you create this large ability to just simply have one person call a multi-county grand jury, you take away the ability for the grand jury to properly protect those who may be falsely accused. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you for your testimony.
Our next speaker is Virginia Sheehan. Virginia, if you can unmute yourself.
I am unmuted. I am prepared to testify on a different amendment that it was my understanding that Senator Feltus was going to add to this bill or propose to add to this bill. I don't know whether that has gotten to the committee. It wasn't read by Chair Hennessy, so I'm a little unclear on the process here.
That actually, thank you for asking. That will actually be the next amendment that we are speaking to.
Great. I will come back on at that time. Thank you very much.
Thank you very much.
See. Our next speaker is Donald. As I recall, he might be in the same boat with Virginia, but I'll bring him in. Donald?
Correct. Not this amendment, but the next amendment.
Okay. Right.
Confusing.
Got it. Let's see. Other than that, I do have a list of people who have signed up to speak on this, but I believe they may have intended to speak on House Bill 687 instead, but I'll go through them. Michelle Level, I do not see her signed up to speak. If you are interested in speaking to the amendment to House Bill 1249, please raise your hand and we'll come back to you. Same with a Patrick McCarthy. I do not see him signed up to speak, or I do not see him on the attendee list. If you are interested in speaking, please raise your hand and we will come back to you. Let's see. Daniel Stewart. I do not see him on the attendee list. If you'd be interested in speaking on the amendment to House Bill 1249, ask that he raise his hand and we will come back to him. Next speaker I have is, I believe it's Hollis Willoughby. Again, I do not see him on the attendee list. If you are interested in speaking, please raise your hand and we will come back to you. Our next speaker is Mary Crook, and I do not see Mary signed up to speak. Obviously, please raise your hand and we will come back to you. Our last two, I believe, is Tonda Grotzinger, I think is her name. And I do not see her signed up to speak here either. Again, interested in speaking, please raise your hand. And our last one is Laura Hopkinton, who I believe spoke earlier and said she planned on speaking to House Bill 687. If I have missed anybody, please raise your hand, but I believe that concludes the speakers for the amendment on House Bill 1249.
Thank you very much. At this point, what I would like to do is suggest that we close the hearing on,
Recess the hearing, Senator.
I'm sorry, recess the hearing on, thank you, on 1249 with the amendment to 1249, which is 1550S. And we are going to go into, I'd like a motion to go into executive.
Sorry,
Yeah.
so sorry, we just need to give a specific time that we're going to come reopen the hearing.
Okay. So I would suggest that we reopen at 9:45. Does that meet with everyone's? Okay, so let's recess and go into executive set. We're recessing the, do we need to vote on the recess? No. Okay, good. Then we will recess the hearing on the amendment 1550S and go into recess at this point. And I would like to ask for a motion once we're there to go into executive session. So are we all muted from the public? Griffin, we're ready?
To recess, or you're talking about, or to enter executive session? I'm so sorry.
That's okay, to recess and then, and during the recess, enter executive session.
Yes.
So
yes.
we're all set, Senator. We just need someone from the committee to make a motion to go into executive session.
Okay.
I motion we go into executive session.
Second.
With a motion was made by Senator LeVake and seconded by Senator French.
Can we just check? I requested to unmute Senator Carson and she's still muted. I just want to make sure that she's present since she's not on video. I can't tell.
Yeah, I'm here. I'm here. I'm just trying to figure out what's going on. That's all.
Okay.
What are we doing? Why are we recessing? Why don't we just go into executive session?
The prime sponsor is running a little bit late, but he is going to be here. And so we are going to, we thought, I actually had originally hoped that we might exec the first bill that we heard because so people don't have to wait until the very end, which could be quite late.
Can I ask? Don't we have to be in public when we exec?
We are in public. We are.
Oh, we are.
Yeah.
Okay.
We just recessed the hearing, not.
Okay.
the meeting.
Okay, right. Okay.
Okay, thank you.
We're still streaming and everything. Everyone still has access to viewing. So we're just in executive session, and Senator Hennessy was just wondering about members of the committee being muted or not.
Right, gotcha. Thank you.
Senator Chanley, you're unmuted, yes? Yes.
Yes, I am.
So we have a motion and a second on executive session, so we just need a roll call on that.
A roll call vote. Senator Chanley,
Yes.
Senator LeVake,
Yes.
Senator Carson,
Yes.
Senator French,
Yes.
and I will also vote yes. So we are in executive session, and I would like to entertain a motion on, we're going with, do we do the bill first?
Yep, so we'll do a motion on 1375 first for discussion purposes, and then discuss the amendment. I know Senator Person also brought up the with versus within, I believe, online as well.
Right. So I'm looking for a motion on House Bill 1375.
I would move ought to pass on House Bill 1375.
Senator Chanley moves ought to pass on 1375. Is there a second?
I second.
Senator LeVake seconds. Is there discussion?
If I may, I would like to move ought to pass on the amendment 1548 to House Bill 1375.
So that would be Amendment 1548S.
So just to be clear, do we want to address the with versus within in a committee amendment, or do you want me to request OLS to make that change in enrolling? It's up to the committee.
It's up to the committee. I'm perfectly fine with doing it as a committee amendment. I mean, that just means we don't have to do it in the full body.
Yes.
Yeah.
So I don't have that amendment for some reason. What does it address?
So Senator French, do you mean the amendment 1548, or do you mean the question that Senator Carson had about the with versus?
1548 S, that amendment with me.
I did send it to you this morning, but I'm going to resend it to you right now, okay?
Okay.
It's in the calendar as well.
So I've had a couple of questions just now about whether or not we're supposed to be seen and heard by the public, but the answer is yes. Is that right?
Yes, and we're still live on YouTube, and we're still recording, and we're still live on Zoom.
Thank you. So do you have that, Senator French?
I'm looking.
The wording that we saw was in the amendment, not the original bill.
I just resent you the amendment, Senator.
Sorry? Yeah.
I just resent the.
Oh,
Senator
good.
French,
Okay.
So he
great.
should have it in.
Great. Are there any other opinions about having that be a committee amendment to change with to within?
It would be very easy either way. So if it's more comfortable for the committee to do it as a committee amendment, just to make sure, then that's perfectly easy to do.
But the
We would
other
just need
option,
Senator. The other option would be to request that OLS make the change in enrolling.
oh, in enrolling, but that's fine with me as well, which is probably easier.
It would be
Doesn't matter.
easy. Yeah. it
Are
doesn't
there,
matter.
are there other opinions about that? Senator Carson?
The only reason I brought it up was I didn't know if there were going to be other things added or taken away from the amendment. If it's something that can be taken care of in enrolled bill, then fine. But I would like to bring up on page 2, beginning on line 2 and 3. I'm a little concerned about this. This has come forward fairly quickly, and I feel very uncomfortable about putting this into statute and looking and hearing Attorney Smith say that this can actually take away from people who do have physical symptoms. I mean, usually and when you look at some of these suits, there is a lump sum of money that's been put aside to address damages. And if you have people coming forward that they don't have any kind of proof of present physical injury or symptoms, is that going to take away from the individuals that do have physical symptoms or a physical injury? I just feel very uncomfortable with this. It's too fast. I wish we had had more time to think about this and to reach out to get additional information. So at this point, I don't think I can support the amendment. I just would like more time, and we just don't have the time. And I don't want to pass something just to pass something and get it in place. I want to do the right thing. And so I can't support this amendment.
Thank you, Senator. Senator French?
Yeah, thank you. I kind of agree with the Senator Sharon. You know, I would like to be able to vote yes on this bill, but I think it has to be more focused. A broad mandate such as this just makes it impossible for me to vote for it. You know, we're trying to address PFAS problems, and as we should, but the way this is written right now, I can't support it. I suppose if the committee would be willing to make those changes, just striking physical injury or those three words, then I could support and give bipartisan support to this.
Thank you. Thank you, Senator. Are there any other comments or questions? Seeing none, I would just like to remind the group that we have been, this bill was heard and worked on for over 1.5 years. So they, of course, the House heard all of these issues before us. So
Well, this is the Senate, Senator, and
am I in the wrong place?
we come up with the answers real quick.
Yeah, we do. We are quick on the draw. Are there any other questions or issues before we vote on ought to pass? Senator Levick.
Thank you, Madam Chair. I just wanted to weigh in, and I think it's really important that whether it's PFAS or any other type of toxin or danger to the populace, there needs to be accountability. And we need to monitor this process very closely so that it's fair to businesses. But if there are companies that are polluting our water or our soil in any other ways, we need to be able to identify that, and there has to be some kind of recourse. So I think this is important. And again, we have to monitor it closely. Thank you.
Thank you, Senator Levick. And Senator French.
Just to follow up, Senator, thank you. And I agree, the PFAS problem is a big problem the state is facing. I want to address it, and I would like for this group to put forward legislation that has a chance of being signed into law.
Thank you, Senator. Senator, looked like you had something to say.
Did you say me?
Yes.
Thank you. Yes, thank you very much. I guess I just want to remind the body that we did consider a medical monitoring bill that we had testimony, we spent some time with it. We did pass it out of committee. It had a favorable vote out of committee. But then when the work was being done in the House, I did sit in on many of those sessions. I was very impressed by the really fantastic work that was done in a bipartisan fashion, and the bill that amendment that we looked at right now is the result of the amendment put forth by the work put forth by the House, and I'm really impressed by it. And while I come from a district that does have many concerns about PFAS exposure, and I certainly want PFAS exposure to be addressed. I recognize that there are always new and different toxins created, and I do not, it certainly isn't my intention to limit this legislation to being beneficial only to those who are exposed to PFAS. And I think that anyone who is negligent in harms others through toxic chemicals should be held accountable through medical monitoring. I really do appreciate the amendment suggested by Senator French, but I think that essentially makes it impossible. The point of medical monitoring is to say, yes, you've been exposed to these chemicals, they are harmful, and you may suffer consequences. To say that we need to prove before the monitoring begins the existence of physical injury seems to me a little bit putting the cart before the horse. So thank you very much, Madam Chair.
Thank you, Senator Chanley. Senator Carson wishes to speak.
Thank you, Madam Chair. I believe we heard testimony that we all have some level of PFAS in our systems. So I agree that we need to do this, but I just don't think this bill is ready for prime time. If you want to talk about targeting areas that have been identified as having PFAS issues, I can support that. But this is just a blanket. It's too broad. It's just way too broad. And so, I mean, if we want to talk about PFAS, because seems that that's what the issue is, then let's make this about PFAS and make this about PFAS monitoring. If you lived in these areas, that you would be monitored. And I think that's something we can all get behind. But right now, this is so big, it could be for anything. And how do you, I just think we're going too far, too fast. It's too broad. We need to narrow this down. It needs to be focused on the areas that have been affected by PFAS, and stick with just PFAS, because I think we can all agree that these folks have gotten this toxin into their bodies in an unacceptable amount because of the drinking water. So let's focus on PFAS. Let's focus on restricted and certain areas where we know that there have been problems, rather than a broad program that we don't even know what the parameters could be. So again, I can't support this as it is right now. In fact, I'd like to probably see this as part of a larger PFAS package, because we've had a lot of legislation dealing with PFAS. So again, thank you very much, Madam Chair, and I'm hoping that we can come up with something that we can all agree with.
Thank you, Senator. What we have, as I understand it now, we have a motion of ought to pass on the amendment.
So we have a motion from Senator Chanley. We do not have a second, and I don't think there's been an agreement yet about whether or not we want to change it to with or within.
Oh, okay. Is there anybody who has first of all, I will second the motion. And so is there any other feeling, Senator Chanley, Senator Carson, you brought it up. Do you have a strong feeling about whether or not this is amended as a committee amendment or by the OLS?
Sorry, I have to go let the dogs in. If we're not changing anything at all, then let enrolled bills take care of it.
Okay, thank you very much. Okay, so I would like to do a roll call vote on, I'm sorry, do you want to let your dogs in and come back?
Mute Sharon.
Okay. Okay. we will vote we will vote slowly. So the motion is ought to pass on the amendment 1548. And I would like to call on Senator LeVake to vote.
Yes.
Senator Chanley,
Yes.
Senator French,
No.
Senator Carson,
No.
and I will vote yes. So the amendment 1548 has passed 3-2. And so now I'd like to seek a motion on House Bill 1375.
So we already have a motion, Senator, from the beginning
Oh,
by
that's right.
Stanley and Levake, so we just need to call the roll.
So we'll just call the roll with the ought to pass motion on House Bill 1375. Senator Chanley,
Yes.
Senator LeVake,
Yes.
Senator Carson,
No.
Senator French,
Oh,
and I will vote yes. So again, that is a ought to pass is 3-2. And I would like to designate Senator Chanley, if you would, to take this out.
Yes. Thank you.
Thank you. Okay. I think we're ready to go on. No?
But you just need a motion to go out of exec. And
Right. So are we ready to go out of exec?
I move we go out of executive session.
Moved by Senator LeVake,
Second.
seconded by Senator Chanley, and we will vote on the motion to go out of exec at this time. Senator Chanley,
Yes.
Senator LeVake,
Yes.
Senator Carson,
Yes.
Senator French,
no.
and I vote yes. So we are going to leave Senator French in exec. No, just kidding.
Senator, we have about 2 minutes still before we can begin for 12:45. So.
Oh, good, because I would like to take a very brief break to get some coffee. Thank you.
So everyone will be back at 9:45. 1
Good.
minute.
Okay. Yeah, I see Senator LeVake, but I can't tell whether Senator French is back from a fresh air break or Senator Chanley Carson.
I'm here.
Senator Chanley is here. It looks like Senator French, are you there? Not quite. Senator Carson? Okay, we'll wait another minute or so. I see Senator French. I understand the need for fresh air.
Oh, it's marvelous, marvelous here. On the lake,
On the
beautiful
lake.
breeze.
Senator Carson, are you here?
She had to let her dogs out again.
Who let the dogs out? Okay, so should we wait another minute or go ahead? We'll go ahead. She'll be here momentarily, I'm sure. So I'm going to open reopen, come out of recess is what I think I should do. Yes,
That's
got
right,
it.
be good.
Okay, so is there a motion to come out of recess? No, we don't need to have a motion to come out of recess. I am just saying we are coming out of recess. How's that for power? Okay, so we are going to, I would like to invite Senator Feltis to come forward and to speak to Amendment 1566S.
Is he even here?
I'm here.
Good morning, Senator Feltis.
I figured it out. Thank you very much, Madam Chair, members of the committee, Senator French, Senator Carson, Senator LeVake, Senator Chanley. Great to see all of you via Zoom. An honor and privilege to be before your committee again, Madam Chair. Members, wanted to present an amendment for your consideration that deals with remote notarying and wills. So what this does in a nutshell is allow for an accommodation of, at least on the notary provision, remote notarization consistent.
Interrupt you. So sorry, Sarah, to interrupt you. I just want to let the public know that your amendment that you're referencing is on the general court webpage for anybody that would like to see.
Thank you.
Oh, thank you, Jenny. Appreciate that. So again, in terms of remote notarization, it basically codifies, it does codify emergency order 11 pursuant to executive order 2020-04. And that's important to do that. It lives for the state of the emergency. It's important to do that for a variety of reasons, including if there's a possible challenge of the authority in order number 11, for example, maybe a disgruntled family member looking for a reason to challenge. We want to make sure that that emergency order and the actions taken subsequent to that during the state of the emergency are valid. It does similar revisions to in terms of the wills provision. And again, it only lives during this state of emergency. And so that's the general gist of what this does. It's been worked on by a variety of attorneys. You'll hear from some today. It's been worked on by the Trust and Estate Legislative Working Group. There's no objection to this from Judge King and Judge Netto. And so I think Justice Netto, excuse me. And I think that it represents a good prudent course of action to deal with this in light of the emergency that we're under and the need to do these documents, including in a remote manner with video conferencing, including in some cases with people in nursing homes. And so I think it's an important measure to take right now. I will note, Madam Chair, members of the committee, on page, there's a couple edits, unfortunately, that I would like to flag for the committee in this amendment. So if you can flip to page 4 of the amendment, line 15 on page 4 of the amendment, it says new paragraph, uniform law on notarial acts, I guess, remote video witnessing and notarization. The words witnessing and is not necessary because this is a process, it's a notary process. So the 2 words should be deleted on line 15, the words witnessing and. The second, and I think more important hiccup here is on line 25 through 27 on page 4. It says on line number 1, 2, and 3 lists the type of person that can help with this notary process. But we need to, on line 25, there's an and that should, if you see the and midway through, and then there's a clause, and the person and the notarial officer, notarial officer, I don't know if I'm pronouncing that correct, Madam Chair, can communicate simultaneously by sight and sound through an electronic device and process the time of the act. So that would actually have require just that.
I think you're breaking up.
Paragraph B. Can you hear me okay now?
Yes.
Okay.
Can you
I
just-
suggest.
Can you just go back, Senator, and start?
Yeah, can you go back? Yeah. Go back to
Oh.
25 through 27, please.
Thank you very much. Can everybody hear me okay now?
Yes.
Okay, good. On line 25, about 3/4 of the way through that sentence, there is the word and. That hiccup here is that that's supposed to be a separate requirement. In other words, take everything after and put it in a new paragraph B, if I'm making sense. So items 1, 2, and 3 are the types of people that can do it. And then after and is a requirement of the action of doing the notary. So make a separate subparagraph B, and then at the end, add the and at the end of line 27, and change the lettering B on line 28 to C.
Got it.
Is that okay? Good. And then the last edit is just on line 30. There's a comma after emergency order number 11. That's unnecessary. You could just delete that. So those are the three edits. And again, you're going to be hearing from a number of people who worked on this. Obviously, we're unique and challenging times. This is an important issue to, I think, deal with. And I want to thank everybody who's going to testify and everybody who has worked on this. And I want to thank Judge King and Justice Neto for their involvement in this as well. So with that, Madam Chair, I'll be happy to answer any questions. But again, we got, I think, some attorneys that are ready to testify on this and testify about the need for it.
Thank you, Senator Feltus. And Senator French has a question.
Yes, I do. Thank you, Madam Chair. Senator, are you still with us?
I am.
Good to hear your voice. So
good to hear your voice too, Senator French.
So this amendment of yours sounds reasonable. What am I missing?
I love you, Senator French.
Thank you.
You're welcome.
Are there any other questions or comments? Seeing none. Thank you, Senator Feltus.
Thank you very much, Madam Chair.
And we will begin to call other people who'd like to speak. And this is for Amendment 1566S.
See. All right, so just to clarify, we are having a public hearing on Amendment 2020-1566S to House Bill 1249. I do see that there are a number of hands raised. I'm not sure if they're interested, but if you're interested to speak on House Bill 687, that public hearing has not started yet, and it will take place after this hearing. Continuing on, I will call people who wish to speak on Amendment 1566S to House Bill 1249. Let's start with Virginia Sheehan.
Good morning. I am Virginia Sheehan, and I'm a trust and estates attorney. I have practiced for nearly 30 years, which I hate to say, but anyway, because it makes me old. But I'm a longtime trust and estates attorney in Concord, New Hampshire. And several years ago, I formed the New Hampshire Trust and Estates Legislative Working Group, which has a long name, but it's really just a group of attorneys, and we trust and estates attorneys. And we work on bills having to do with trust and estate law in New Hampshire. We're not lobbyists. We're just trying to review bills proposed by lobbyists and also review bills and laws in New Hampshire to propose changes to make the practice and the laws better for the people of New Hampshire. During the pandemic, there have been conversations all over the country and many in New Hampshire about how we help our clients with estate planning. It's a very personal process. We've had to change to Zoom like you have here. And that works great for our meetings, but with many people, elderly people are a challenge, obviously, but with the technology, but as long as they have somebody helping or they're with, able to do it themselves, that works fine. But the signing process has been a real challenge. We are doing signings outside. We are doing signings remotely where we can, but you cannot sign a will remotely. You have to have two witnesses in the presence of the testator, who is the person signing the will. The law of wills is very, very, very old, hundreds and hundreds and hundreds of years. This is a very old law, which is fine. And we all understand that we want to protect our clients from undue influence and everything else. But during this pandemic, it's causing issues. So the first amendment here has to do with, as Senator Feltes said, really confirming and ratifying the executive order number 11 so that we as estate planners have confidence that we are protecting our clients and that there will be an excuse to challenge a estate planning document that has been notarized remotely during this pandemic. Unfortunately, probate litigation is a big business now, and so we are all hyper vigilant on behalf of our clients for these issues. The second amendment that we have proposed has to do with remote witnessing of wills. And what we were proposing is that the attorney who has drafted the documents, who knows the client, will be the notary and will be on a Zoom or other platform like this with the two witnesses and the testator, where they can all see and hear each other. And in that circumstance only would it be considered.
I'm sorry to interrupt, Senator Hennessy. That spends 3 minutes.
Could I just finish my sentence? So anyway, that would be considered in the presence of, to satisfy that old requirement in the wills statute. So I just thank you for your time and hope you will vote to support this amendment.
Thank you. Thank you for being here. Are there questions for Ms. Sheehan? Seeing none. Thank you very much.
The next speaker will be Donald, who indicated he wanted to speak on Amendment 1566S to House Bill 1249.
Good morning.
Donald?
Can you hear me?
Yep.
Great. Good morning. Thank you, Madam Chair, senators, hardworking staffers, and Senator Feltus for giving us a chance to get this done during this session. So if our clients are on the 3rd floor of a nursing home that is very understandably during COVID-19 not letting lawyers or anybody else in, and we can't get our 2 witnesses up to the 4th floor to peek in the window of the nursing home, we can't do wills. That's what this is about. There are just 2 sections. The notary statute is being changed to expand the definition of what does it mean to appear before a notary. Up till now, we've always assumed that means sitting across from my desk in my office, and that just says you can do it by Zoom. The notary still has to identify the person. And then the other statute, the will statute, says, what does it mean for a witness to be, quote, in the presence of the clients or the testator? Again, it just means we can do it by Zoom or any kind of video. And so I thank you. This would make it a lot easier for us to do our jobs. And there are many citizens in New Hampshire who cannot make wills today who would be able to do that. So thank you very much.
Thank you for your testimony. Are there questions? Senator French.
Thank you, Madam Chair. Just a quick question. Are you capable of determining competency through Zoom? Do you see a problem with that?
Senator, I don't. I've done about a dozen of these, and it's the same process as I do when my clients are physically sitting in front of me. I say, Senator French, when were you born? Who's the president? What's the weather like outside? Do you know your kids' names? Do you know what you own? What do you want to do with that stuff? If I get a bad feeling about any of those answers when the client is sitting physically in front of me, I stop the process. Same thing if I see it happening by Zoom.
Great, great. Thank you.
Any other questions? Seeing none, thank you very much for being here, Donald, and we'll go on.
Our next speaker we have to speak on this amendment is Judy Kenny with her hand raised.
Welcome, Judy.
Judy?
It looks like Judy's muted.
Yeah, I've asked her to unmute herself. Judy, if you can unmute yourself on your end. We will come back to her. Oh, Judy?
Hi, sorry, I didn't think I marked that I wanted to talk. I just wanted to listen to what was going on.
Okay, all right. We'll take you off then.
All right, thank you.
And let's see. Our next and final speaker on this amendment is Ken Park. If there are any other people who wish to speak on this amendment, please raise your hand and we will get to you.
Yeah, greetings. My name is Ken Park Jr., and I'm just kind of curious why the chat is disabled. That's all I have.
Can we? Oh, I'm sorry. I believe I'm sorry. The chat.
The chat's disabled for the webinars. That's how we've run the procedure through all the Senate hearings. If you do have comments or concerns, you can email them to remote Senate, the email address given at the top of the hearing, and we can address your concerns there. Thank you.
Okay, I thank you for that. I did email this morning, but there was some concern that, if we had to interject, we wanted to.
Understandable.
Sorry, that's just not how it's being done, or even in person.
So let's see. I'm not seeing any other comments from any other people regarding Amendment 1566S. I do see Laura Hopkinton. Give me one moment to bring her in.
Good morning, Laura Hopkinson here. Thank you so much for your time, team. Quick question about the different forms in which you will be verifying your client's stability or capabilities to coherently sign and execute such documents. With a background in cybersecurity and former DoD, there's definitely platforms out there that have information stating they're more secure than others. Is there any consideration to what is or isn't allowed as a form of video? For example, Google Hangouts versus Zoom versus Cisco's WebEx. They're all completely different infrastructures. Some are housed in the cloud, some are housed on premise. Wondering what considerations have been given to those
So Ms.
items.
Hopkins, thank you for your questions, but we do not have a format where we ask questions of the committee. You're more than welcome to offer testimony to the committee members, but we do not have a format in the Senate where people testifying ask questions of the committee.
Understood. Thank you.
Thank you.
Other than that, I'm not seeing any other hands raised who wish to provide feedback on Amendment 1566S. Seeing no hands, I think that concludes the testimony for this amendment.
Thank you. I would like to close the hearing on Amendment 1566S. And we are now going to open the hearing on House Bill 687 FN and call on the prime sponsor, Representative Altschuler. Welcome.
Thank you. Can you hear me?
Yes.
Wonderful. Thank you very much. My name is Representative Deborah Altschuler. I represent Stratham, District 19 in Rockingham County. Thank you, committee members and Chairwoman Hennessy, for your service to our state and for being so flexible in being able to manage our duties via Zoom. This is a highly unusual way to do it, but let's go. I'm not sure because I can't see how this whole process rolled out, but do you have the copies of the testimony that I submitted prior to this hearing?
I do. Do others?
Okay. Well, then I'm going to go through, I was just checking to see what people had, so I didn't duplicate efforts. And also just wanted to clarify that we all were using House Bill 687 FN as amended by the House, because I will be referencing that in my testimony with the lines in that that are printed out from that amendment, pages and lines.
Yes.
Yes, thank you. Okay, so we bring House Bill 687 to you for consideration. This is an extreme risk protective order. It's a public safety bill with public health implications. The intention and the purpose of this bill is to address the gap in current New Hampshire statute that leaves families and law enforcement powerless when they see with their own eyes and hear with their own ears a loved one in crisis exhibiting suicidal ideation or threats to harm other people. So what is suicidal ideation? It is the thinking about or having an unusual preoccupation with suicide. The range of suicidal ideation varies greatly from fleeting thoughts to extensive thoughts to detailed planning, role playing, and incomplete attempts, which may deliberately be constructed not to be completed or discovered, or may be fully intended to result in death. And if you refer to NAMI New Hampshire's website, you can actually see a white sheet on suicide where we got most of this information. Suicide in New Hampshire is the second leading cause of death for people between the ages of 10 and 34. And half of those suicides are with a firearm. 50% of New Hampshire residents who die by suicide use a firearm. Between 2013 and 2017, nearly 1,200 New Hampshire residents died by suicide. Nearly half of all those suicides in New Hampshire were carried out with a gun, resulting in the deaths of over 550 New Hampshire residents. When someone uses a firearm to attempt suicide, that attempt is lethal 90% of the time. That is 90% of suicide in using the most lethal means available. I pointed out that suicide is the second leading cause of death for New Hampshire residents between the ages of 10 and 34. And you may be wondering what is ahead of that. Cancer for those ages 10 to 14, and for the 15 to 44 group, it's overdoses. When faced with these kinds of facts, what do? Do we throw our hands up and say, oh, this is just terrible, but you know, cancer is going to happen. There's nothing we can do to prevent that. Do we say, oh my, so many people overdosing. What a shame. I feel so bad for them and their families. No, we don't do that. We take actions. We take lots of actions. We put awareness programs into place to teach people about the hazards of exposure to certain chemicals and poisons that cause cancer. We do awareness campaigns to teach the public about prevention strategies, like not smoking around children to protect them from secondhand smoke. We create drug abuse prevention programs, legislation, campaigns, and public outreach to alert people to the dangers of addiction. We put support programs in place for those who are affected to help them recover and heal. We do, we act, and we recognize that it's not just one thing we do, but a comprehensive series of things. Will one measure taken by this body solve the tragic increase in the number of suicides in New Hampshire? Will one measure prevent any and all future firearm-related tragedies? Realistically, no, one thing won't, but a collaboration of prevention, training, outreach, and recognizing that people in crisis deserve protection from accessing the most lethal means available will help turn this around. That's our job here today, to do the most good for the most people. The Extreme Risk Protective Order is designed to put a speed bump in front of a person who has access to the most lethal means available to do themselves and others harm. It creates a tool for the people closest to someone suffering to prevent tragedy and to get them help. It temporarily relieves a person who is demonstrating they're a danger to themselves or others around them access to firearms, temporarily standing between them and the most lethal means of doing harm to themselves or others around them. Currently in New Hampshire, there are 3 other statutes that relieve people of their rights to have access to firearms. The first, there is a domestic violence restraining order that is contained in Chapter 173B for use in those cases crimes of abuse have been committed that pose credible threats to a petitioner's safety. Chapter 173 is available to spouses, ex-spouses, housemates, former housemates, parents, aunts, uncles, and anyone else who may be living with the abuser and is suffering abuse. The other avenue that leads to someone being temporarily relieved of their firearms is the stalking statute, which is contained in New Hampshire Chapter 633(3), which applies to someone purposely, knowingly, or recklessly engaging in stalking another person to make them fear for their safety. Both of these are criminal statutes, as they should be. The third statute that temporarily relieves a person of access to firearms is located in Chapter 135C of the Title 10 Public Health Chapter, and it is the involuntary emergency admissions. This is a drastic measure and has a high threshold to meet. It involves being transported in handcuffs to a medical facility for evaluation after a family member files what is called a complaint and prayer for compulsory mental examination. Then, if the person is in need of psychiatric help, they wait in the emergency room because the backlog for admission for services to the state psychiatric unit is weeks long. On February 25th, when this bill was first presented in a House committee, there were 36 adults parked in emergency rooms. Last week, on Thursday, June 18th, there were 21 adults waiting for inpatient beds across the state. And just yesterday, after I submitted my written testimony, I got an alert that 28 adults are still waiting in 26 New Hampshire emergency departments. This is a crisis all of its own, which I hope demonstrates that we have a gap. We have a gap between when someone has committed a crime and has been deemed too dangerous to have access to firearms while that crime is being adjudicated. That's 173B, the DV protection orders, and 633(3 stalking orders. And then if we go over onto the other side of the gap, the high bar of an involuntary commitment to a state hospital. So what's available for people in crisis who are in that gap? Families who see their loved ones' behaviors escalate in dangerous directions have only one option available to them: a well check by their local law enforcement. You will hear testimony today of law enforcement agencies whose well check response yielded partial relief because the person they were checking on was open to recognizing they were a danger and open to receiving help. And you will also hear testimony where law enforcement was unsuccessful, but had nothing else to offer a terrified family whose loved one was noticeably struggling, and there were no tools available to stop them from acquiring, possessing, and using the most lethal means available to do harm, a firearm. House Bill 687, as amended, creates an extreme risk protective order to fill this gap and provide a tool, a civil order, to families and law enforcement to help those people in crisis. Family and household members are on the front lines of this crisis. They see when their loved ones are exhibiting warning signs and pose a significant risk of harm to themselves or others. They see, hear, and feel the danger signals. And as you will hear from witnesses today, they feel helpless to protect them from lethal harm to themselves or others. The pandemic has changed the way this hearing is being conducted. When the first hearing for this bill was held, we filled the Hall of Representatives, and we intended to fill your regular committee room too, a sea of red shirts and families impacted by gun violence. These hearings, even now, will be raw with emotion and a difficult place for survivors of gun violence to be, yet they are bravely going to share their pain so that others might not have to experience the same horror they did. This civil protective order is only for extreme risk. On page 3 of the bill, in section 149E4, labeled temporary relief on lines 22 through 24, it says the court shall issue a temporary extreme risk protection order if it finds, and this is the part I'd like you to pay attention to, is by a preponderance of the evidence that the respondent poses an immediate and significant risk of causing bodily injury to himself or herself or others by having a firearm or any ammunition in his or her custody or control, or by purchasing, possessing, or receiving a firearm or ammunition. If and when an extreme risk protection order is issued, a hearing must be held within 7 days of the filing of a petition, or within 4 days after the petition is served to the respondent, whichever occurs later. If the respondent would like to speed up that process, they may request the hearing be expedited, and the courts will conduct the hearing in no less than 3 and no more than 5 business days after making the request. Family or household members who file for an extreme risk protection order must do so under penalty of perjury. That's in section 159E3, which is located on page 2, lines 25 through 27. Petitioners must appear in court to defend their petition, and this is key. Under no circumstances are there any allowances for anonymous petitions. There's a lot of misinformation being flown around this bill that people can drop a hint to some sort of a tip line, and it will trigger a extreme risk protection order to be executed, and that is actually untrue. This bill contains extensive due processes. The eligible petitioners are limited, and they carry the burden of proving extreme risk. A final order cannot be put in place until a full hearing is held with both respondent and petitioner present. A quote, final order is almost a misnomer, as this extreme risk protective order is temporary by design and limited in scope. It can be put in place for no longer than 12 months. The processes and procedures contained in this bill mirror processes and procedures that we already have in place here in New Hampshire. We are not creating new and different processes and procedures, only an avenue to access them. So is this being addressed on the federal level? The short answer is yes. Nationally, the need for extreme risk protective orders have been recognized by both the White House, the Senate, and the House of Representatives. In March of 2018, the White House has issued a white sheet calling on every state to adopt extreme risk protective orders and directing the Department of Justice to assist them. Legislation has been filed in both the House and the Senate, the Bureau of Justice Assistance is being directed to form discretionary grants for states that put these in place. Are there other states doing this? Well, when we began this journey, 13 states had extreme risk protection orders. Today, 19 states and the District of Columbia have enacted extreme risk protective order laws. By 2018, with bipartisan votes, 8 states and the District of Columbia had passed laws, and by today we're up to 18. So the states with extreme risk protective order laws are California, Colorado, Connecticut, Delaware, District of Columbia, Florida, Hawaii, Illinois, Indiana, Maryland, Massachusetts, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, Virginia, and Washington. Attached to the testimony I submitted to you is a status of state red flag laws that is in the shape of the United States of America, and it's color coded, so you can take a look at that. It's attached to this testimony. In none of these states have there been a successful constitutional challenge to these laws. They hold up. Our version, our New Hampshire version of an extreme risk protection order is unique to us. While the intention of harm reduction by the most lethal means available is a common thread with these other states, we have crafted legislation with New Hampshire stakeholders and have honored the input and concerns of mental health professionals, law enforcement, domestic and sexual violence advocates, civil liberty unions, and the family members left behind. This is not—
Representative Altshuler, I just want to ask you if you could please wrap up in a couple minutes.
I'm just about done here. Yep.
Thank you. Perfect.
This is not a cookie cutter piece of legislation. It has been carefully crafted to reflect the needs of our state. We would like for New Hampshire to join the 4 other New England states, Connecticut, Massachusetts, Rhode Island, and Vermont, that have extreme risk protection orders, so we too have this tool available to prevent tragedies within our own borders. Mass murder is not inevitable. According to the Brady Campaign to Prevent Gun Violence, 42% of mass shooters exhibited warning signs before committing their crimes. We can take steps to turn this national crisis around so that we never have to offer our thoughts and prayers when we could have offered strong policy and action. And suicide is not inevitable. Suicide is preventable. There are people who want to help and families who don't want to have to pick up a shovel and bury their husband, wife, sister, brother, father, or mother, or child. There are families here today who never thought they would bury a child, but they have, and they're here to share their pain with you. They will relive their worst days to educate all of us as to why an extreme risk protective order would spare others from pain. I have also submitted to you a petition that in its original form is contained in a 2.5-inch wide binder that has over 770 signatures from 112 cities and towns, from Londonderry to Colebrook, Keene to Durham, Nashua to Bow, and everywhere in between. The citizens of New Hampshire have made it clear that passing this extreme risk protection order is a clear priority. I thank you so much for your time and attention, and I'm open to answering any questions you may have.
Thank you very much, Representative. Are there questions from the committee? I can only see Senator LeBake, so I'm guessing that there are no other questions, but thank you so much for your testimony.
Thank you. Do I mute, or is Jennifer gonna mute me?
I'll take care of it.
Griffin will take care of it.
Thank you, Griffin.
Yep. Let's see. Our next speaker I have is Ken Norton. Ken, give me just one moment here.
Thank you.
Welcome.
Madam Chair and committee members, thank you for the opportunity to testify today. My name is Kenneth Norton, and I'm the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness. On behalf of NAMI New Hampshire, I'm here to offer strong support of HB 687, specifically as a mechanism for preventing suicide. Public debate regarding gun violence is focused on homicide and mass shootings. However, close to 2/3 of the gun violence deaths in the US are suicides. Debate is also focused on mental illness rather than dangerousness, on purchase of guns rather than access, and on lifetime bans rather than temporary removal. NAMI New Hampshire believes that this bill addresses each of these concerns by focusing on dangerousness, looking at access, and recognizing the removal of firearms should be temporary. Suicide is a significant public health issue in New Hampshire. Sadly, a 2018 US Center for Disease Control report identified New Hampshire as having the third highest increase in suicide deaths of any other state. And I won't reiterate all of the data that Representative Altschiller gave, but I will just say again that 5 years in New Hampshire with a total of 1,240 suicide deaths, 589 of them, or 48%, involved using a firearm. On March 18th of 2018, the National Rifle Association took an official position in favor of extreme risk protective orders, issuing a video called "We Can Prevent Violence and Protect Freedom." NRA Executive Director of Legislative Action, Chris Cox, stated, and I quote, "We need to stop dangerous people before they act, so Congress should provide funding for states to adopt risk protection orders. This can help prevent violent behavior before it turns into a tragedy. These laws also allow courts to intervene and temporarily remove firearms when a person threatens violence to themselves or others." On December 18th of 2018, President Trump's Federal Commission on School Safety issued its final report, which dedicated a whole section to extreme risk protective orders. The report states that President Trump has called on states to adopt extreme risk protective orders that protect the rights of law-abiding citizens. The report notes under commission observations, quote, "The available evidence suggests that the older risk warrant laws may have a positive impact on suicide prevention. States should adopt extreme risk protective order laws that incorporate an appropriate evidentiary standard to temporarily restrict firearm access by individuals found to be a danger to themselves or others," end quote. And I will send written testimony with links to these reports. NAMI New Hampshire believes that the best course of action for a firearm owner who is a potential danger to themselves or others is for family members or friends to intervene and seek to voluntarily remove firearms from the individual. However, we've seen firsthand the tragedy results when this does not happen. We recognize that this bill is an extreme measure and should only be considered when other less
I'm
intrusive
sorry to interrupt.
alternatives have been
Senator
attempted.
Hennessy, that's been 3 minutes.
NAMI New Hampshire believes that, that this bill provides sufficient due process and that suicide is preventable, and this is an important mechanism. We ask you to vote for it as ought to pass, and I'm happy to take any questions you have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, we appreciate your testimony, and we will move on. Thank you.
Thank you.
Sorry, next person I have is Representative Jerry Knirk. Representative?
Okay, yes, Ed, can you hear me now?
Yes.
Yes.
Okay, thanks. Yes, I am representing Jerry Knirk, and I represent Carroll County District 3, and I'm also a retired orthopedic surgeon. This bill basically is a public health approach to dealing with gun violence. We know that public health is concerned with that, protecting the health of the entire population, and the approach often strives to begin to prevent the injury rather than wait until after it's occurred. Though school shootings and other mass shootings often grab the headlines, the majority of our firearm deaths are due to suicide. And guns are much more lethal than other means of attempting suicide, with a fatality rate that approximately is 85%. So access to a firearm, meaning either personal or household gun ownership, increases the risk of suicide by 3 times. If a gun is not easily accessible, the attempt is less likely to result in death, allowing that person to obtain health for the factors in their life that led them to consider suicide. Our first responders, emergency physicians, and trauma surgeons do a superb job of trying to save the lives of gunshot victims. However, when suicide is attempted by a firearm, most people die before they even reach the hospital. Improving our care system at the hospital will not make a significant impact. Instead, we need to try to prevent the suicide attempt by firearm. After mass shootings, gun rights groups frequently call for addressing mental health problems. This bill provides a tool to do that. It's important to understand that it does not advocate for restricting access to firearms simply because someone has sought mental health help or is living with a mental health diagnosis. Restricting access to guns with an ERPO requires a finding that a person poses a serious risk to themselves or others based on a pattern of dangerous behavior. After mass shootings, we often hear the story that there are a number of behavioral signs that had people worried. There are also often warning signs for suicide. An ERPO law allows the family to call for help before the person is hurt. The spouse may note the despondency of her husband after the loss of a job, notice the purchase of a new gun, and then statements like, the world's going to be better off without me. With this law available, that spouse can have the opportunity to protect her husband from what appears to be a significant risk of harming himself. Connecticut's ERPO law was associated with a 14% reduction in the state's firearm suicide rate. HB 687 is a common sense public health approach to the problem of gun violence and should be supported. Thank you. I'll take any questions.
Thank you very much, Representative Knirk. Are there questions for the representative? Seeing none, thank you for coming to testify.
Thank you.
I would like to, we have, I think, about 50 more people to speak, and we want to be able to hear everyone. So I want to remind people, please do not repeat the testimony of others. I know that's hard, but try to cut it down to some new ideas and new thoughts rather than to repeat. Thank you very much.
Next I have to speak was Representative Tim Horrigan.
Welcome, Representative Horrigan.
All right, there, I'm unmuted. I sent you some written testimony, so obviously that would have taken much more than 3 minutes to read it all and would probably sound stilted. What it boils down to, this bill keeps firearms out of the hands people who shouldn't have them, and there are some people who shouldn't have them. Not just because of the risk of suicide, which is very important, the risk they'll shoot someone else, but even if they shoot someone else, that's very difficult for the shooter too. That's like a very unnatural thing for a human being to do. That's not in my testimony, but I thought I'd say that. We're going to hear many objections to the bill, except I'm speaking before the 50 people who have the objections have come up. But I remember what I heard in 2019 and 2020 when this bill was in the House. I think first we're going to hear that guns are not the only things as weapons, and that's actually 100% true. But as Representative Altschuler pointed out, these are by far the most dangerous weapons, and guns basically exist only for the purpose of killing other living creatures. That's what hunting is. Even target shooting, you're practicing to kill another creature, and those are great sports, and I don't disapprove of them. And even if you're merely brandishing it, you're threatening to kill the other person. So, about the due process, there's a lot of due process in the bill. I don't think I've ever seen a bill with so much due process. The standard of proof is very high just to get the temporary order, and then the permanent order requires an even standard higher to proof. That's as high as any other civil proceedings. And finally, you're going to hear that a man in Maryland was shot and killed in the police because of that state's red flag law. At least I assume you'll hear about it. And I won't be surprised to hear no further details about it from anyone by myself. And I looked into it. A man named Gary Willis was indeed shot and killed by 2 police officers in Anne Arundel County, Maryland, near Baltimore. And of course, I feel differently about officer-involved shootings after the tragic events of the last few months than I did before. But I still think this was justifiable. The man's name was Gary Willis, so remember the name Gary Willis. He's one of many people who have been shot by the police officers, just like George Floyd, Breonna Taylor, Rashard Brooks, the others. But it's a terrible tragedy, but it was not the fault of the red flag law. In fact, if anything, the red flag law probably made it less likely. So he'd had a long-running dispute with his family. His mother had filed a petition, and so it was They obviously didn't handle right if a citizen gets shot, but Mr. Willis, the red flag order against Mr. Willis, judging from what I've seen, was a good idea and was properly entered. And it was, as I said, it was entered by his mother after months of tension, weeks and months of tension between Mr. Willis, Gary Willis, and the other.
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
Yeah, and then sadly, actually today would have been Mr. Willis's birthday, but it's not the red flag law's fault, though. Red flag law made this type of incident less likely, and that's the only incident I know of anywhere in the country of a citizen being killed during a red flag protective order being served. So thank you.
Thank you, Representative Horrigan. Are there questions? Seeing none, thank you for your testimony, Representative.
Pass it as is. Yeah, thanks.
Next, we have lined up to speak is Representative Mary Jane Mulligan. Give me just 1 second.
Okay.
Yes, thank you. Welcome.
Well, thank you. Thank you. And it's still good morning, Madam Chair. And also, good morning to all the esteemed members of the committee here. I am, I did send in written testimony. My name is Mary Jane Mulligan. I'm Representative Mulligan. I'm from the Grafton District number 12, Hanover and Lyme. And I am here to support of HB 687 as joining the 86% of Americans who are also in support of the red flag ERPO bill. So I'm just going to do a quick summary, and because there's been a lot of discussion. Here is what Bill 687 does and doesn't do. The main thing is it saves lives. It will provide an avenue for concerned family members and law enforcement to ask the courts for assistance in protecting someone who is a danger to themselves or people around them from using the most lethal means to do harm, a firearm. It will not be available, as some who oppose the bill assert, to angry neighbors, frustrated coworkers, or anyone who just has a grudge against someone and wants revenge. That is specifically blocked. Those asking for an ERPO must swear in court that their statements are true under penalty of perjury. The New Hampshire ERPO does have a full due process incorporated in it. The constitutionality has been tested in other states and upheld by the US Supreme Court. ERPOs are a civil order. They are designed to protect the public safety when there is extreme risk. The petitioners and respondents, the petitioner are those asking for the extreme risk protective order. The petitioners may ask the court for an extreme risk protective order, and the courts, though, are under absolutely no obligation to grant the order, only to hear the petition. Now, should a judge decide to grant the temporary order, a hearing must be held no sooner than 3 days and no later than 7 days. It is not a criminal proceeding. There are no arrests, no fingerprints, no criminal records. No one is prosecuted in the criminal courts. There is no guilty or innocent in this civil order. ERPOs will prevent people who are at extreme risk to themselves and others from using their own firearm to do harm, and from them acquiring a new firearm or ammunition during the length of the order, which the order could be as short as—
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
Okay, thank you, Representative Mulligan. Could you just finish the last sentence, please?
Yeah, I'll just finish up. That was a fast 3 minutes. Okay, I'm sorry. But absolutely no longer than 12 months, okay? And ERPOs do not prevent people from ever having a firearm again. And you heard about how the suicide is on a rise here in New Hampshire. I am just asking that you please vote in support of this bill and know that by doing that, you are going to be saving people's lives. Thank you for listening to my testimony.
Thank you, Representative Mulligan. Are there questions? Seeing none, we'll move on.
Our next speaker is Representative Deb Stevens. Representative?
Yes, thank
Yep.
you. Thank you for taking my testimony. I represent Nashua Ward 7, and that is roughly 10,000 of my neighbors. And not all 10,000, but a lot of my constituents want to reduce gun violence, and 687 would do just that. I also want, and I've submitted this testimony, although I had trouble with the email address, so I'm getting help working on that. But I also, in my previous life from my being a representative, I've been in the mental health profession for more than 30 years, retired now, and I can testify that red flag laws save lives. I know this to be true from doing hundreds of assessments and countless involuntary emergency admissions to New Hampshire State Hospital for children and adults. It's an arduous process. And I explain this to people to understand, what the laws are. And I just wanted to briefly go through a story that, despite that it happened more than a decade ago, haunts me, which is doing an assessment, having the entire family show up with the look of terror on their faces, and me, the clinician, being hamstrung from not being able to legally consider certain evidence, if you will. I interviewed everyone and as a group, and had to discharge that person nonetheless. Nonetheless, everything in my training screamed red flag, but the people who this isn't their first rodeo knew how to answer the questions that I was legally obligated to ask, and so forth. And the entire family, all adults, had to leave, and as each of the family members left, looking at me, glancing at me, everyone's face was a face of horror, even though I had explained to them what my limitations were in doing my work of assessment. And
thank you so much. Your time is up. If you are finishing a sentence, feel free to go ahead.
I actually am. 10 hours later, the exact scenario that the entire family shared with me took place. And that was the tragedy that could have been avoided had there been red flag laws.
Thank you so much for your testimony and for being here. Are there any questions? Seeing none. I'm just going to remind everybody we still have an awful lot of people to get through, and there's no penalty for being less than 3 minutes.
Our next speaker is Representative David Corson. Give me just 1 second. Representative?
Yes, can you hear me?
Yep.
Good. I'm David Corson from Rockingham County District 1, Northwood, and I appreciate the opportunity to speak. I support HB 687, and my support's based on 40 years of work as a family doc and then a psychiatrist, working in the trenches and treating thousands of individuals committed under RSA 135C. I'm also commenting as someone who grew up with firearms, and I'm very comfortable with them, and I have great respect for those I know and love who taught me what I know about firearms. And I want to speak to 3 points that I understand to be major oppositions to measures like 687. And 2 of them I want to speak to together. The first one is it's wrong to intervene like 687 by allowing ex parte hearings. And the second is that it's wrong to intervene because of concerns that something might happen without anything actually having happened. Commitments to a locked psychiatric facility are justified based on probable cause in the absence of a hearing or even a specific event of actual physical harm, but the concern that it might occur because of a mental illness. Commitment entirely constrains the respondent's freedoms far beyond the temporary access to firearms. The argument that the lesser constraint of someone's temporary access to a firearm requires greater protections just doesn't stand up in light of our appropriate decision to enable involuntarily commitments without them. And then the third point I want to speak to individually, the potential for abuse. This comes up over and over again. First thing I'd want to say is, having been involved with thousands of cases where people have been committed, I personally have yet to have an experience with a petitioner who abused their rights. The times when things have been abused, they've been abused by the patient themselves, but not by petitioners. They are extremely reluctant to come forward. I expect that that would continue. In addition, the present ERPO, the burden of proof on the petitioner is greater with a preponderance of evidence, and the penalties of perjury are significant for a false petition. And both reduce the likelihood of any abuse even further. I don't think you can ever rule out the possibility that abuse occurs in this and just about every other constraining legislation that we have. But I think the numbers of that are going to be vanishingly small compared to the number of events where something beneficial has occurred. And the evidence points that way pretty strongly. If you look at the most recent study out of California, looking at 1,000 petitions from 2016 to 2019.
Sorry to interrupt, Senator Hennessy, that's been 3 minutes.
Thank you. So please just finish your last sentence.
There's no evidence of abuse, and there is evidence that it's averted mass shootings, and there's clear evidence that it averts suicides. Thank you.
Thank you very much. Are there any questions? Seeing none. Thank you for being here.
Thank you.
Next speaker I have is Joe Hannon. Give me a second to find him. Joe, if you can unmute yourself.
Hello. Hi, can you hear me?
Yep, go ahead.
Hi, my name is Joe Hannon. I'm a former state representative. I'm also the vice president for gun owners of New Hampshire, and I'm speaking in opposition to HB 687. We've heard some talk about some of the possible benefits of it, and we also heard, I believe, one representative talk about someone who was killed because of enforcement of this this law. I'll get to that in a moment, but there are a lot of problems with this bill. Specifically, sorry, hold on one moment, sorry. I'm not even going to go into the Second Amendment violations of this, but I'm sure other people will get to that. But there are serious Fourth Amendment violations to this. The Fourth Amendment requires probable cause for searches and seizures, but this bill seeks to allow searches and seizures of firearms and ammunition, provided the court has reason to believe that such firearms or ammunition have not been relinquished by the respondent. That does not meet the burden of the Fourth Amendment protections against searches and seizures. That is one of the reasons that probably led to the death of the person that you heard mentioned, Gary Willis, in Ferndale, Maryland, about 1.5 years ago. Gary Willis was a 62-year-old Black man who was basically met by the police around 5 in the morning. He was woken up. He showed up to the door with a firearm in his hand. He was handed the order by the officers. He put the firearm down to read the order. And Apparently there was, some very serious angst at being woken up and being told his property was being taken out of the blue with no warning whatsoever. He probably was agitated, apparently, according to police reports. And there was basically a situation where a firearm did go off and police did shoot him to death. Now, this was in November of 2018. Imagine if this had happened 1 week ago. There was reference that the killing was very similar to the killing of George Floyd. And it was, I think the next comment was that it was justified because this had, a lot of due process. Well, there's not much difference when you're woken up in the middle of the night and killed by police at your door with no warning whatsoever. This gives law enforcement the ability to do something like that to anybody. And under the environment we're living in right now, I can't imagine what would happen if the same event were to not occur in November of 18, but in June of 2020. The morning after it occurred, the chief of police in that area in Arundel County, Timothy Altamar, said, if you look at this morning's—
Senator Hennessy, that's been 3 minutes.
If I could have just another moment, please.
Just fit to finish the sentence as others have been allowed. Thank you.
If you look at this morning's outcome, the chief said it's tough for us to say, well, what did we prevent? Because we don't know what we could have prevented or could have prevented. What would have happened if we didn't go there at 5 a.m.? Probably nothing. Also, during as many years as a resident of his home in Ferndale, nothing untoward happened. His niece, Michelle Willis, said, I'm dumbfounded right now. My uncle wouldn't hurt anybody. This person this law opens up the ability for an ex-partner, family member, or anybody to make an accusation that is not basically to the same standard of any criminal case to take someone's rights away. And that is completely wrong. There's a lot more, and written testimony has been submitted. Thank you.
Thank you. And I'd like to see, are there any questions for Mr. Hannan? Senator French.
Thank you, Madam Chair. Thank you, Representative Dr. Joe. Do you know why the police were sent there in the first place?
I don't have all of the details, but I believe that his family had some differences with him. I don't know what they were. He'd lived there for many years with not a single incident or problem. His neighbors thought he was peaceful and quiet. There was no real crime in that neighborhood that people had been reported. That was on different newscasts that neighbors had said. So this could be just from someone who doesn't like what's going on, doesn't like a family member. There are some people, and also the burden of the punishment for filing a false report. Many people have said, oh, well, they have to sign an affidavit under penalty of prosecution. It's a misdemeanor if you file a false charge, but if you violate the order, it's a felony conviction possible. So It's not fair, and it sets people up for a lot of retaliation or harmful effects.
Great, thank you for your testimony.
Thank you.
Further questions? Seeing none, thank you for your testimony.
Thank you.
Let's see. Next, I will go on to Laura Hopkinson, who has her hand raised.
Good morning. Thank you so much, everyone. Appreciate your time. Laura Hopkinson of Meredith, New Hampshire. I'd like to testify that as a concerned citizen, not here in any official capacity, who had almost 10 years with the Department of Defense and the Department of the Air Force, as well as doing consulting across the nation for our schools' safety and emergency response systems, and a supporter of police and a supporter of Black Lives Matter. I'm concerned that although the intentions of this bill are good, it does not reflect our current environment today. Knowing you work for years at times to present legislation such as this, it doesn't reflect the environment in which our own public safety can shift overnight. It doesn't reflect the environment where court and your opportunity to have a trial properly happens swiftly. So I'm really concerned about our current environment and this bill. Although I do appreciate its intent and I do support where we're headed, I don't think this is the answer. Thank you for your time.
Thank you very much. Are there any questions for Ms. Hopkinton? Seeing none. Thank you very much for your testimony.
Let's see. Our next speaker, Joseph Cameron.
Can you hear me?
Yep.
Hi. So I just wanted to introduce myself. I technically don't live in the state right now. I'm on active duty in U.S. Army Special Operations. So my experience with guns, I think, probably far out exceeds the majority of the listeners here. And that being said, I first want to make a comment regarding the individual statement on firearms, and the only purpose is for killing. Now, yes, the argument can be made they're used for hunting and self-defense per the Second Amendment. I know many people, including myself, who use them as a great way to relieve stress. Many of us have a lot of stressors in our lives. It's not just me, everybody does with all the stuff that's going on. And firearms are, I actually believe, are not a great way to relieve stress. I know that might sound crazy to many of you who have never shot firearms, never partaken in the use of firearms. That is one thing that they are used for. So I do feel that the comment that they're only used to kill someone or something is just arrogant and short-sighted for those who own them for purposes other than that. I also want to make note that many of the states that you listed with similar bills for red flag laws and other things have some of the highest rates of gun violence in the United States, yet they have some of the most strict gun laws. So there's a direct inverse relationship between gun laws and gun violence, as seen with California, Washington, D.C., which is one of the most dangerous cities in the entire country. And then states like New Hampshire, which have some of the most lax gun laws, yet have some of the lowest rates per capita of gun violence. So again, increasing laws doesn't necessarily mean that you're going to magically be safer. And then next, I'd also like to point out that though you all contend that these laws are not going to allow individuals to just make a phone call or say that this person's quote unquote dangerous because they don't follow with what the government is saying or with what the mainstream news or any other people might say or contend, is that eventually will go there. And we know that there is a slippery slope. We see it in all these states, such as Maryland, such as Virginia, and other states where they use these laws initially with quote unquote good intent, and then it ends up being used with malicious intent later on. And there are multiple cases in which this has been seen. And I get that we're all trying to protect other people. We want to prevent gun violence. We want to stop mass shootings. We want to stop suicide. Again, I can tell you firsthand, being in the military, I've had quite a few friends who've committed suicide, and their guns were taken away from them by their own friends and family. They still found another way. And these people were getting psychological help and therapy. And I'm not saying that you can't save somebody. I'm not saying that one life isn't worth saving, you know, compared to somebody else's. But what I am saying is that you can't equate taking away civil liberties, constitutional rights, with a blanket statement of that, well, we got to save everybody from suicide. We have to save everybody from themselves who wants to do harm. And as the other gentleman
to interrupt, Senator Hennessy, that's been 3 minutes.
Thank you.
Okay, well, I'm going to wrap it up real quick. I also want to know what constitutional, what laws you have to abide by when you're trying to take away constitutional amendments such as the Second Amendment, the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment, and the Eighth Amendment, which are all involved when you take away someone's right to bear arms without due process and without a speedy trial. And then when you don't have to take and properly handle those firearms, and if they're destroyed upon return of those firearms, the individual who paid for them then has to fix it, not the government who took them.
Thank
I'll end
you.
with that.
Thank you very much for your testimony. Are there questions? Seeing none. Thank you for being here.
Next speaker is Bob Clegg.
Can you hear me now?
Yep.
Hi, my name is Bob Clegg, and I'm representing Pro Gun New Hampshire, a nonpartisan group of gun owners. And I won't repeat what was already said, but when we look at the idea of red flag laws, we need to look beyond our own biases and look to see what the unintended consequences will be. The death you heard of the man who had a red flag law served on him, that was served because he and his sister had a family argument at a family gathering. She apologized later, admitting she'd done it for revenge. So there's a good example of what's wrong. Here in New Hampshire, we have examples of people writing threats on Twitter or Facebook seeking violence against a political opponent. Recently, Representative Deb Stevens from Nashville published a piece claiming supporters of President Trump are planning a mass slaughter if the president isn't reelected. She states they're amassing weapons and ammunitions for the purpose. Her post is full of the hate and bigotry she declares Trump's supporter has. She purposely uses the actions of the recent riots and destruction and claims them as the action of Trump supporters. She leaves no doubt. She would call the police and red flag every person who supports President Trump and does not support her Democratic nominee. But she isn't alone. On a national level, John Kerry just days ago claimed a history of, and I quote, certain officials of a certain party purposely making it difficult for the other party to vote where they control those matters, unquote. John Kerry further says Trump supporters will cause a revolution. Another person considered a Democratic leader looking for red flag reasons to attack any person who disagrees politically. This bill seems to have resurrected after the rejection of Mr. Terrell, and suddenly we hear and see the words of the above leaders in our democratically controlled legislature appearing to play to a base. The same base tearing down statues, destroying businesses, but saving its inventories. The same base looking to defund any agency that may be in place to be sure all people are safe. The timing is very troubling to me. How do I know this is not a political shot across the bow of the ship captained by Mr. Terrell, the man deemed a token by Executive Counselor Andrew Volinsky as he was denied a seat at the table by all three Democratic executive counselors? What fear is pushing the need to create a method to confiscate the freedoms of those who disagree with the ruling party? This is not Congress, this is New Hampshire, and I'm not willing to see us pass it so we can see what's in it, and I cannot be supportive of a bill so we can see what might happen. You cannot undo the death of even one person caused by false accusations. The rhetoric of supposed leaders is poison to a free society. Instilling fear has done little more than dramatically increase the number of people.
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
Thank you very much. Mr. Clegg, please conclude.
Okay. I'll conclude with saying that if you pass this bill, the guilty are guilty until they can prove their innocence, and they have to be able to afford that. And I'm going to ask you to, ProGun asks you to pass the recycling bin and leave this bill in the trash can on your way out the door.
Thank you for your testimony. Are there any questions? Senator French.
Thank you, Madam Chair. Thank you, Senator, for your testimony. Just a question I had, it was running through my mind while you were speaking. What would happen if a gun shop owner was accused?
He would lose every gun in his shop, and then a year later, maybe get them back. And then that's assuming that he's making enough money to actually afford the ability to defend himself against somebody who's mad at him, maybe an ex-girlfriend.
Would he lose his licensing also?
Absolutely. And the idea that this would go unnoticed by NICS is wrong. In fact, there's a law in place in the state of New Hampshire that anybody who's accused is automatically going to have to be turned into the federal government. So just the fact that you've been accused and there's any kind of psychiatric intervention, you're now going to be prohibited from owning a gun or ammunition. And there's no way to get yourself off the prohibition when it's in the NICS system.
Thank you.
Are there further questions? Seeing none, thank you for your testimony.
Thank you.
Next speaker I have is Clyde Bacon.
Hello.
Can you hear us, Clyde?
Yes, I can, and I tried to hit the unmuff my voice. I would like to not repeat things. I will make 3 statements that are very simple, and in response to people that have talked, these statements are very accurate. 11 years I was a pilot in the Air Force. I've dealt with weapons. I have been involved in deaths. I had an instructor pilot, a brilliant man, who served his country 4 years in the worst of weather in Europe. He was smart enough to fly a complicated interceptor. He was a family man. He was everything. And after I became an instructor, he shot himself to death. In 1965, through the Vietnam era, we faced death as a possibility. We still did our duty. But we were all shocked that somebody with the talent, the education, would commit suicide. Why, we don't know. But buying time with the red flag law, your friends or something could have interceded, that may not have happened. Now, the military has some very nice slogans, and this you probably haven't been given. The one I like the most is keep it simple, stupid. It's not a condemnation of people's actions. It's a reality that the most complicated of maneuvers can end up making the problem worse than what they thought. In this case, why not keep the laws simple? And why not look at the rights of people equally with the responsibilities that people have? The second quick item is acceptable losses. Leaders, generals, colonels, whether it's peacetime exercises or wartime interventions, they all have to work with the idea of acceptable losses. The NRA and the talking heads that support the various gun lobby groups think and propose business proposals based on acceptable losses to them. To families, 87% or something of the Americans are in favor of sensible.
Sorry to interrupt, Senator Hennessy, that's been 3 minutes.
Well, I will give you one finish of that sentence, and
Thank
it
you.
is you people, as our national leaders, also have a responsibility to answer the call from the majority of Americans who want sane gun laws. Thank you.
Thank you very much for your testimony, Mr. Bacon. Are there any questions from the Senate? I see none. Thank you for being here.
Thank you.
Our next speaker is Robin Skudlark. I hope I'm saying that correctly. One second. Robin, if you can unmute yourself on your end.
Ooh.
Yep, we can hear you.
Oh, good. Hi. Okay, so my name's Robin Skudlarek. I've lived in New Hampshire for 29 years. I currently live in Londonderry, raised my kids here. I've been a volunteer with Moms Demand Action for 5 years, and I'm here to speak in support of HB 687. I'll try not to repeat stuff, but I speak really quick, so I should be done in no time. In my work on gun violence prevention over these 5 years, I have a close view of the lives impacted by the epidemic of gun violence that is unique to our country. My family has been personally affected by this overwhelming epidemic. We know that every day more than 100 people die from gun violence, and nearly 38,000 die each year. Mass shootings are on the rise, but what doesn't get enough attention or make the news, and what's particularly personal, is gun suicide or suicide by firearm. In our state here in New Hampshire, a resident dies every 3 days from suicide with a gun. It's tragic and unacceptable, particularly given that we have many ways to reduce this affliction on our society. Our veterans and their families experience suicide by firearm most acutely and at an alarmingly high rate. We know that attempted suicide by gun is far more lethal than other means of ending one's life. And we have a way of stopping that with red flag or the ERPO law. tragic acts of gun violence, including mass shootings and suicides, are often preceded by red flags defined as threats of violence, dangerous behavior, and other indications that a person poses a risk of harming themselves or others. Since the Parkland shooting in 2018, 15 states and DC have passed red flag laws, more than tripling the states that have these laws nationally. Many of these bills were signed into law by Republican governors. In the 10 years after Indiana passed its red flag law, the state's firearm suicide rate decreased by 7.5%. In Connecticut, the red flag law was associated with a 14% reduction in firearm suicide rate when enforcement of the law increased significantly after the Virginia Tech mass shooting in 2007. Red flag laws empower family members and law enforcement officers, the people that are most likely to see these warning signs, to intervene by enabling them to seek a court order temporarily restricting a person's access to guns when they are in crisis. ERPO is just a tool that can help us save lives by allowing those closest to the person in crisis to act upon the warning signs and prevent another tragedy from occurring, a tragedy that happened to my family. 15 years ago, a close family member, my brother, attempted suicide by a gunshot to the head. Statistics will tell you that suicide by gun results in death about 90% of the time. Compare that rate to suicide attempt not involving a gun, in which less than 4% will result in death. My brother somehow survived his suicide attempt, his gunshot to the head. Miraculous would be a more appropriate word. He somehow survived, but not without deficits. Excuse me, sorry.
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
I have just like one paragraph. Can I just?
If you could just finish up the sentence, I apologize, but we do need to be rigid about that.
Well, he somehow survived, but not without deficits. Part of the bullet is still in his head. He had exhibited signs of depression. He was about to be evicted. He was in a crisis and he had a gun. We tried everything we could, going to police, going and trying to get the gun taken away. And had we had this life-saving tool available, it would have saved him. And I'll just go on to say that he is still alive at this point. He did not go on to ever attempt suicide in another way, which is what a lot of people will say. He would have found another way. He did not. Thank you for your time.
Thank you very much for your time.
I have my written testimony, I hope. So if someone can just check on that, I did email it.
Yes, thank you.
Thank you.
You got it. Thank you.
Are there questions? Seeing none. Thank you.
Thank you.
Our next speaker is Dave Brialt. Give me 1 second.
Can you hear me?
Yep.
Welcome.
Hi, thanks for having me. I'm David Brault. I live in Salem, New Hampshire. I worked as a clinical social worker, psychotherapist for almost 50 years. For those years, most of those years, I worked at the University of New Mexico in the Department of Psychiatry. I am now retired. I am speaking in favor of HB 687. For several years, I have been a volunteer with Moms Demand Action, the gun violence prevention group. I remember talking to a woman named Nina, whose younger brother struggled with depression and killed himself with a gun he bought impulsively. I'll never forget the helplessness in her voice as she talked about trying to get him to get rid of the gun because she knew he posed a threat to himself with it, and wishing she knew a way to get help to remove it. She feels guilt at herself and anger at therapists for not helping her brother, and she misses him terribly. I became involved with gun violence prevention because of my work as a therapist and the struggles with trying to help people like Nina's brother. The pain that survivors live with is so excruciating and can impact them for their entire lives. I feel obliged to do what I can to reduce the ever-increasing cause of such pain. For every gun violent incident, there are a great many people who become vulnerable to experience post-traumatic stress disorder. These include witnesses, family members, friends, helpers, etc. I have a disturbing image of concentric circles of PTSD emanating out of every incident in the fabric of into the fabric of our society. I refuse to accept that we can do nothing about gun violence in our society. The ERPO bill is a reasonable law which protects individual liberty and provides meaningful tools that will prevent further suicides and homicides. I won't give the statistics, they've already been given. We can and must do something about this. I have worked with many suicidal people. I know that by responding in extreme situations and removing the means of committing suicide, we can save lives. When a person is plagued by suicidal thoughts and feelings, they are in an incredibly vulnerable and isolated place. They seem like they don't want help, but they do. If they attempt suicide with a gun, they have very little chance of survival. Please vote in favor of this bill. It truly gives us a tool in our toolbox for saving lives in New Hampshire. Thank you.
Thank you. And thank you for your brevity. We, I'm sure, have a great many more to go. And so we appreciate those of you who are not repeating previous testimony. Are there questions? Seeing none. Move on. Thank you.
Next speaker is Kimberly Moran, I think. Give me 1 second.
Hello, can you hear me?
Yep.
Welcome.
Whoops. Sorry, this is awfully strange, senators. I'm actually speaking as a representative for the Women's Defense League in New Hampshire. It was only a few years ago that we finally ended almost 100 years of state-sanctioned discrimination against law-abiding granite staters, a law that allowed governing bodies and law enforcement to discriminate at will against constituents who wanted to practice their fundamental human right to self-defense by carrying a firearm concealed. It's now 2020, and we're here to fight more state-sanctioned discrimination against law-abiding granite staters who dare own firearms or ammunition. At a time when people are screaming from the rooftops about discrimination and equality, the legislature is trying to pass a bill written by an out-of-state organization that is one of the most discriminatory pieces of legislation to be heard in decades. The people pushing this bill may believe it's okay to discriminate against law-abiding citizens who own firearms, but those citizens come from all walks of life. They are made up of all races, sexes, socioeconomic backgrounds, and sexual orientations. The supporters of this legislation claim it's to stop people from harming themselves or others, yet this legislation does nothing to actually stop people from doing either. And we have cases to prove that, where red flag laws were enacted, yet the person got no help and still went on to harm someone else. There is no crime that has been committed. There's no laws that have been broken. A law-abiding citizen is denied their fundamental human right to self-defense based on secret meetings with anonymous petitioners who claim they know exactly what a person is thinking about doing in the future. The red flag bill is nothing but a modern day witch hunt. The Salem witch trials ended in the 1600s. They should never be brought back. Passing this legislation brings the Salem witch trials to the Granite State, only instead of being on trial for being a witch, law-abiding granite staters are on trial for being gun owners. If the proponents of this bill are truly concerned about people harming themselves or others, they would work on the existing involuntary admissions law that actually provides due process, gets people the help they need, and doesn't discriminate against those who own inanimate objects. They would work to make mental health more accessible for those who need it. This red flag bill isn't about protection. It's about gun confiscation. Please vote in opposition to this out-of-state legislation. New Hampshire is consistently one of the safest states in the country. This legislation will make granite staters, especially women, less safe.
Thank you for your testimony. Are there questions? Seeing none, thank you for being here.
Our next speaker is Tracy Hahn Burkett.
Hi, can you hear me?
Yep.
Yeah.
Great, thank you. I'm Tracy Hahn Burkett. I'm the leader of the Kent Street Coalition's Working Group on Gun Violence Prevention. Excuse me, and I will submit my full written remarks. How many times have you seen on the news a tragedy, after a tragedy where people have died by gunfire, people in tears asking, there were signs, why didn't anyone do something? And how many times have you heard those who vehemently defend the Second Amendment tell you the gun doesn't act on its own, it's the person holding the gun? And how many times in the midst of the COVID-19 public health crisis that we're in now have you considered the awful tally of the lives already lost and the lives still to be lost? And what if I told you that we've been living under a different public health crisis for decades, gun violence, that has already claimed more American lives since 1968 than those lost in all the wars we've ever fought as a country combined? And what if before someone starts to tell me again how New Hampshire is different from the rest of the country because we're so safe, I refer you back to the statistics Representative Altschuler cited regarding the high rates of suicide in our state, especially among our young people. And what if we could actually do something about all of this? Well, we can. HB 687, a bill to create extreme risk protection orders in our state, is one answer. It's not a panacea, but the problem of gun violence here is too complex for any single cure-all. Now, ERPOs are a relatively new construction, so research into their effectiveness is limited, but there is some data available on their effectiveness in various states. So just to cite a few, after Connecticut amended an existing law, its firearm suicide rate dropped by 14%. Indiana saw its suicide rate decrease by 7.5% over 10 years. And in California, one case study found 21 instances where ERPOs averted mass shootings. We're now living in a time where people are suffering from increased social isolation and, in some cases, severe economic hardship at a level not seen in decades. These factors, which will not disappear anytime soon, exist in combination with a recent period of a huge spike in gun sales, meaning there are many more guns available in the community. Given the well-established impulsivity of the suicidal act and evidence that new handgun ownership is strongly associated with suicide, it's critical that there exists some tool to remove firearms from an individual in situations where it's believed they are in imminent danger of harming themselves or others. In conclusion, HB 687 represents an important answer before we get to the point where a devastated community asks, why didn't someone do something before this happened? I urge this committee to support passage of this bill.
Thank you very much for being here. Are there questions? Seeing none, we appreciate your testimony.
Thank you.
Let's see. Next person I have is Sonia Prince. Give me just one moment to bring her in.
Hi. Hello, can you hear me?
Hello, go ahead.
Hi, I'm Sonia Prince from Nashua. I am a financial analyst and I work with a lot of families and business owners. I have 3 sisters who are social workers who work in child protection. So I've had a lot of friends and experiences where I've heard a lot of gun violent victims that likely could have been prevented with laws like this. I'm not going to go into everything that everybody else is talking about, but I do have one client. She has 2 little boys. I went over to her home last year and her husband was at the door and he was armed and he had a dog and he introduced himself and said, I have this dog because I have PTSD. And turns out he had been hospitalized before. So as I left that home, he didn't get involved with any of the conversations regarding finances because he can't. Mentally, he has some severe mental health issues, but he does work as a security guard. He was off work for a little while and had been hospitalized before. So I do worry about her and her kids and him because he has that gun on his hip at all times and he doesn't feel well and he needs the dog at all times. So I think there's a case that there could be some prevention if ever he gets to a point where he needs to be hospitalized again. Would there be a court order that they could possibly remove the gun temporarily to keep the family safe? That being said, I've also read a lot about what they do in California, and what I admire about them, and they've been doing it for years, is that when there are patients who are severely ill and go to the mental health care in a hospital and admitted, and the people working with that person admits that somehow they are a danger to themselves or others, the police gets a list and then they go home to home as needed to verify if the people have their guns in place, if they have registered guns to their names, and they remove them. And one particular individual that comes to mind, they had checked the vehicle, and when they opened the trunk, there were multiple guns, multiple bags of ammunition, and they had duct tape and rope in the trunk. So they believe that there was possible intent there of doing something really, really damaging. And that's an issue. I also have a coworker who lost her brother 2 years ago to suicide. And she feels that if she had had access to that, she could have petitioned the court and possibly saved her brother's life, because she knew he wasn't feeling well and she knew the gun was in the house. So that's all I have to say. I'm not going to repeat all the other stories. I could give you countless examples because I did volunteer with Moms Demand Action. So I know a lot of victims who have lost, not victims, but parents of victims who have lost a lot of children. And it's really incredibly devastating to look at that graduation book that they made of these students who never graduated. So I hope you pass this bill. Thank you. Oh, I can't hear you, but I think you can hear me.
Okay, sorry about that. Thank you for your testimony. Are there questions? Seeing none, thank you very much for being here.
Thank you.
Our next speaker is Daniel Stewart, but I do not see him on the attendees list. Dan, if you're calling in by phone, please press *9 to raise your hand and we will come back to you. Our next speaker is Gregory Smith, who I think I saw earlier, but I no longer see him here. Gregory, if you're calling in by phone, please press *9 to raise your hand and we will come back to you. Our next speaker is Tom Bloomquist.
Good morning, ladies and gentlemen. Thank you. I learned to shoot as a young lad because that was one of the few sports available to a polio kid. I would hate to think that outdoor sports are only available to able-bodied people. Okay, that was one of the few things I could do. Next, when I'm getting a divorce, I removed all firearms from the house, called the chief of police, notified him of same, but when it came to the conversation, the first thing she did was pick up the phone, call the police, crazy man with gun, come, please help me. And the police came storming through the door. I had removed all guns. I had notified the police there were no firearms in the house. And still, if it wasn't for the good judgment of the police, I could have very easily been shot like that other fellow. Okay, the potential for abuse with this proposal is huge. Everybody here has stories of divorces that got ugly, where allegations were made without basis. We need to avoid the potential pitfalls of this. We need to fix the mental health system. I agree with you. There's much more that can be done. But in the process, we need to protect the rights of the majority of citizens. Yes, guns can kill. They can also guard and protect. And especially in this day and age, citizens need that capability. I thank you for your time, ladies and gentlemen. Any questions?
Thank you very much, Mr. Bloomquist. Are there questions? Seeing none, we appreciate your being here. Thank you.
Our next speaker is Curtis Wright. However, again, I do not see him on the attendees list. Mr. Wright, if you're calling in by phone, please press *9 to raise your hand. And
I'm here.
Oh, there he is. Curtis, can you hear us?
I can hear you. Thank you so much for having me. I'm a physician, a Navy veteran with 40 years in public health. My interest in this is that my brother-in-law was terrorized and ultimately shot by his drug-addicted son. I really want a good red flag law. This is not it. I am speaking in opposition. It's not ready. Example 159E4. A petitioner may request and the court may enter extreme risk protection order with or without actual notice to the respondent. This opens the door to the police at the door at 5 a.m. A good law doesn't pose an unreasonable burden to innocent parties by protecting individual liberty. There is a severe asymmetry of penalties for perjury in this law. And there is a failure to responsibly care for and return seized property. This is not a temporary order. If you read the end of it, you discover that the individual must petition the court for the return of their property, and what has been stated. This will result in immediate petitions against every gun shop owner in the state, and they will be wiped out. Please do not pass this version. It needs more work. Thank you very much.
Thank you so much for your testimony, Mr. Wright. Are there others who would like to ask questions? Seeing none, thank you for being here.
Our next speaker is Paul Maravellius. I apologize if I screwed up that last name.
All right, can you guys hear me now?
Yes.
Excellent. Well, may it please the committee, good morning. My name is Paul Maravellius. I'm from Windham, New Hampshire. I'm 25 years old. I'm a graduate of Dartmouth College in economics, and I speak to you in vehement opposition to this tyrannical proposition called HB 687FN, because I'm someone who has actual on-the-ground experience with what happens in our circuit courts with these flavors of civil restraining orders. I consider myself an expert on the topic, and that's because I had my gun stolen from me for 3 years because of a RSA 633-3A stalking civil petition from no one else than an angry neighbor. And we've heard absolutely vacuous statements to the effect of this bill insulates against angry neighbors, and I can tell you with certainty that it doesn't. So I want to tell you two things. I want to tell you what actually goes on as someone who for fun sits in domestic violence and stalking restraining order hearings of strangers, and just for my own edification, I read all of the case law. I can tell you that there's a criminal conspiracy that our Supreme Court in New Hampshire is actually complicit in to nullify a respondent's right to appeal in this case. And so that's going to be one of my arguments, is that if this bill passes, there will be no meaningful right to appeal. And I'm going to tell you about a criminal conspiracy that the New Hampshire Supreme Court is actually self-censoring and hiding their dispositions in all of these blanket affirmations they give. But I just wanted to mention some things about this bill itself. There is no provision in this bill upon the extension for the court to even explain its reasons for granting an extension. That is a provision that exists in the RSA 173B restraining orders and the 633-3A. It's been removed here. Also, this version is even more tyrannical than the one proposed last year, because the standard of evidence for the temporary relief is reduced to the preponderance of evidence standard. That means it's anticipatable that in 49% of cases, an innocent person's Second Amendment rights will be stolen from them unlawfully by the same government which the United States Supreme Court has held is not able to deprive firearms as a criminal conviction unless be it for a felony crime. That means I can go punch someone on the face in the street and be convicted of a misdemeanor crime of actual violence, and the government is even then not allowed to take away from me my guns as a criminal punishment. That's reserved for felons. But here we have a civil order that violating it is a felony. So if it's unjustly violated, if it's unjustly issued once, and then a person violates it, even if it was unjustly issued, they're still a felon and they can no longer own a gun for the rest of their life. So there are 3 lies that have been spoken to this committee, bold-faced lies I wanted to call out. One of them was the temporary nature. This bill actually permits infinite and never-ending extensions of such restraining orders. And it actually shifts the burden of proof upon the respondent to prove that they no longer satisfy those conditions.
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
Sure. So
Please
the last thing,
finish your current sentence.
to finish my sentence, I would say that the New Hampshire Supreme Court, if you go on the website at the other final orders, you will realize that they have been selectively self-censoring and publishing nowhere their dispositions in the civil restraining order cases. Even if you're a lawyer with a Westlaw subscription, you cannot find them. They've been blanket affirming every single one of them. And out of 6,030 petitions filed in 2018, only 2 reversals were granted, to give you a picture of the horrendous picture of even our current restraining order laws. They need to be scaled back because they've been abused tyrannically, not given such an extreme push forward. Thank you.
Thank you. Thank you for your testimony. Are there questions? Seeing none, thank you for being here.
Our next person up is Lauren LePage.
Hi, can you hear me?
Yes.
Okay. My name's Lauren LePage. I'm testifying today on behalf of the National Rifle Association of America. I would like to state our adamant opposition to House Bill 687. Most of what I will send to you in my written testimony has been covered, so I'm going to save you from repeating that. I do want to say that the notion that someone can be deemed too dangerous to be trusted with a gun because of allegations from a third party is fine to be left alone once firearms are taken away and there's no requirement of a mental health evaluation or chemical dependency evaluation, and no requirement to treatment after the fact, after you've removed the firearms. Doesn't make any sense. And then obviously there are things that people can harm themselves with that are considered lethal weapons outside of firearms. None of that's included in this bill, which undermines the public safety justification for it. And lastly, I just want to, this was mentioned a couple speakers ago, but I want to undermine how unfair it is to require someone, especially in the case that an order is vacated because it was inappropriately granted, to have to pay a lawyer to file a motion in court to obtain their constitutionally protected property to get that property back. Absolutely, a person should not, once an order is vacated or has expired, a person should not have to bear the expense of going back to court to get constitutionally protected property. We believe that this legislation is ripe for abuse, and that's why we are asking you all to respectfully oppose it. And I'm happy to take any questions, but I'll summarize pretty briefly.
Thank you very much for being brief and for your testimony. Are there questions? Seeing none, thank you for being here.
Our next speaker I have is Edward Morse, I believe. However, I do not see his name in the attendees list. Edward, if you're calling in by phone, please raise your hand by pressing *9, and we will come back to you. Our next person is, I believe, Evan Core.
Welcome. He's muted.
Evan, can you unmute yourself on your end?
Hello, can you guys hear me?
Yes.
Well, my name is Evan Core. I'm a resident of Hollis, New Hampshire. And I guess I wanted to introduce myself first and foremost as a competitive marksman. Today, I actually am the New England regional champion of rifle, pistol, and shotgun shooting in the sport of multi-gun. And also have more than 10 years of experience as a coach, as a captain, and as an instructor for the safe and effective use of firearms from everyone through high school students, college students, and competitors, as well as law enforcement and military personnel. Today, I continue to work for the armed forces, although as a civilian contractor. So it would be no small exaggeration for me to say that the majority of my life, in some regard or another, revolves around my ability to own and use firearms in a lawful manner. Obviously, I personally do not have any personal anticipated quarrels with this bill. I am a law-abiding citizen with no unfortunate interactions with anybody, and I also hold a top secret clearance. However, I am nonetheless the target of this bill as a gun owner. There's been a lot of talk so far about the slippery slope nature of this, the fact that although certain people claim to be protected now, they may not be in the future. But again, I don't want to spend too much time repeating what has already been said. One thing I would like to mention, though, is something that Mr. Cameron referenced probably over an hour ago at this point, which is a more realistic and positive outlook regarding the use of firearms for mental health. As I was in school, I currently work for the MIT Lincoln Laboratory as a lead process engineer, and to get the credentials for doing that, I have 3 degrees from the University of Virginia, which I earned at the same time. That was obviously a bit of a stressful proposition, and I can confidently state that my role as the captain of the Bullseye Pistol Team, the availability of not only that structure, but the disciplinary nature of the sport itself was without question the single most positive thing for my mental health from that period of time onward until today. Firearms and their access and the sports surrounding them are a wonderfully positive thing, not just for protection of your family, but also for sport, pleasure, and mental health. It's not an entirely negative proposition. And rather than move on to the constitutional and legal ramifications of this law, I would like to next draw a parallel between this bill and some other current events. As I'm sure you all are aware, in recent weeks, the world over, people have been protesting the fact that government has been deliberately failing to address various systemic issues in society, ranging from institutional racism, unavailability of the living wage, excessive cost of housing, laws against victimless alleged crimes, et cetera, and instead have been using excessive and heavily militarized police to band-aid those problems in a way that is both ineffective and disingenuous. Many of the Democratic members of this committee have come out condemning behavior of that nature.
Sorry to interrupt, Senator Hennessy, that's been 3 minutes.
Just to wrap up that thought, I will simply draw the parallel that attempting to restrict access to firearms or the firearms themselves is very much philosophically the same lazy and disingenuous solution as throwing the police at every problem. The true problems that address why people want to commit suicide and not simply the tools they use to do it is what we really ought to be looking at. And that is a much, much harder problem. We are allies in this. I support those solutions, but this is not that solution. Thank you.
Thank you for your testimony. Are there any questions? Seeing none, thank you for being here.
Our next speaker is Shirley Dawson.
Good morning. Can you hear me?
Yes.
Good morning. Thank you for giving me your time today. My name is Shirley Dawson. I'm a resident of Plastow, New Hampshire, and I'm calling in today to speak in opposition of this bill. I am a domestic abuse survivor, and although I have not experienced that in quite a while, I know that as a gun owner, I have the ability to defend myself. I am 5'3". If I have a 6 foot tall man try to attack me, I'm done if I don't have another way to defend myself. If you take my guns away from me, I have no ability to defend myself if I'm attacked. And let's look at what's been happening in the world lately with people being attacked. The other thing is, the discussion was about suicide. And I understand suicide is a big thing. I understand probably a little better than most people because I'm a former mental health counselor. I worked on secure psychiatric units for a long time. I'm well aware of the IEA and the horse hurdles that one has to jump in order to get someone help through that. So why doesn't this bill address that and get people the help that they need without having to send them to the state hospital and sequester them for 3 days? If healthcare was more widely available to people who are in danger, this would be better help, because all you're doing in taking somebody's guns is forcing them to pick another weapon. Are you going to take the opioids out of their house? Are you going to take the knives, the ropes? Are you going to take the keys to their car? You're probably not. So you leave them with just other choices that they can make. The other thing is that there's no time limit on how long the firearms are taken away from you. And if you're a low-income domestic violence survivor, you don't have the money to get a lawyer to get your firearms back. And your attacker may very well know that you've been disarmed because they may have made a frivolous claim to get your guns away from you so that they can continue to attack you. Please, I ask you to consider getting mental health for people is something I'd love to see happen. But this is a denial of the basic constitutional right to face your accuser when you're accused of something and to have your day in court, because there is no day in court. Your belongings are just summarily taken from you, and you have no redress other than to go hire a lawyer, which you may or may not be able to do. You're not being arraigned or convicted on any charge, so a public defender is not available to you. So this becomes something that you can defend yourself with if you're one of the well-heeled people of society, which a great many people are not. Please do not vote for this. This needs a lot more work, and it is not something that's going to do anything to help. Thank you very, very much for your time.
Thank you for your testimony. Are there questions? Seeing none, thank you for being here.
Our next speaker is Jeff Hyatt. However, I do not see him in the attendees list. Mr. Hyatt, if you wish to speak, please raise your hand by pressing *9 if you're calling in on a telephone. Not seeing his hand, we'll move on to Rob Leatherby.
Good morning.
Morning.
Thank you, Madam Chair, for the opportunity to testify. My name is Rob Leatherby. I am from Exeter, and I'm here today in support of House Bill 687 relative to extreme risk protection orders. I wish to express my support of this bill from my perspective as a gun owner and lifelong registered Republican. You will hear testimony from my wife, Dr. Margaret Tilton, regarding our son, George, who died by suicide in 2017. Knowing George's struggles with depression and how rapidly he could cycle from stability and doing well to experiencing the depths of despair, my firearm was kept in a locked gun safe. Keeping firearms locked up in our home was all we could do to restrict his access to lethal means. Despite his psychiatric hospitalizations and his encounters with law enforcement while being an immediate risk to himself, George was able to walk into a gun store and purchase a handgun, which he did twice. The Exeter police skillfully talked him into surrendering the first one after a concerned friend contacted them, worried about his safety. If such extreme risk protection was available under the law, we would have petitioned for it and George would likely be alive today. George's decision to take his own life was sudden. 3 days before his death, George kept his appointment with his psychiatrist in Boston. 2 days later, prior to going to work, he had a long upbeat phone conversation with his uncle, who said he sounded great, full of plans and dreams for the future. On the morning of November 24th, the day after Thanksgiving, he filled his prescriptions at CVS. Just a few hours later, George was found inside his car at the Dover train station, having died by a self-inflicted gunshot wound. Although people who attempt suicide typically face multiple long-term and short-term problems, research tells us that in many cases, the actual decision is made within minutes of the suicide. George's story illustrates how having lethal means at hand during moments of impulsivity and volatility can result in a fatal outcome. I believe we need laws to limit gun access in the extreme, objectively reviewed circumstances, objectively being the key word. I am a believer in limited government, and I see in this proposed bill a reasonable balance of preservation of individual rights and protection of public safety. Thank you.
Thank you very much for your testimony. Are there questions? Seeing none? Again, thank you.
Next, we'll go to Margaret Tilton.
Good morning. Can you hear me?
Yep.
Good afternoon. Thanks. My name is Margaret Tilton. I am a resident of Exeter, a retired physician. I'm here today in support of House Bill 687. You just heard from my husband, Rob, who told my son George's story. I don't want to repeat. I do have written testimony that I'd ask you to review as well. I just would like to say a couple of things. One of George's encounters with law enforcement, after several that happened when he was a student at UNH, and campus police were involved in talking him down from his suicidal thoughts. The Exeter police came to our home in March of 2016, and it was because a friend of his had called saying that he had on social media expressed that he just bought a gun and was feeling extremely depressed. And I'll never forget the officer's skill in establishing rapport and building trust with my son. He admitted to them that in fact he'd bought the gun because he was depressed. They convinced him to surrender his firearm and talked him into letting me take him to the ER. This resulted in his third voluntary psychiatric admission. Concerned that George would try to get his gun back, I called the police department, was reassured to hear he would need a court order to reclaim it. That would have been true, except that because no crime had been committed, he could have demanded it the day he got out of the hospital, and they would have had to give it to him. George was compliant with his treatment. He always kept his appointments. He took his medication. He was a good kid. He never gave us any trouble. I think it's significant that despite so many episodes of being severely depressed, George had never made an actual suicide attempt. The day after Thanksgiving in 2017, less than 3 weeks after he purchased the second handgun, George fired a gun for the first time. It was his first and only suicide attempt, and the last thing he did in his life. The evidence was there. It was not about a diagnosis or having accessed mental health services. It was a pattern of behavior, severe recurrent mental illness, multiple threats of violence against self, recent acquisition of a firearm. These should have been tripwires for a more robust response. All of us, George's family, his friends, his roommates, law enforcement, tried to do the best we could for him with the means available to us. I respectfully ask you to give us access to better tools by voting yes for this legislation. You will give some nameless, faceless parent who will probably never thank you the ability to keep their child safe, maybe long enough for their loved one to regain a sense of hope and to choose life. Thank you.
Thank you very much for being here. Are there any questions? Many thanks.
Next speaker I have is Heidi Hansen. Give me 1 second.
Hi, can you hear me?
Yep.
Senators, I'm here today in full-throated support of this legislation. My name is Heidi Hansen. I'm a voter from Stratham, New Hampshire. I'm a member of Moms Demand Action for Gun Sense. In 2018, our supporters and allies across the state of New Hampshire elected a gun sense majority to the House and Senate to pass gun violence prevention legislation. The people of New Hampshire have spoken through their vote. Your mandate here today from the voters is to move this legislation forward. 19 states and DC and the District of Columbia have enacted extreme risk protection laws. In these states, due process rights are addressed and balanced against the safety of people who could otherwise become victims of gun violence. There is no shortage of evidence that the presence of a gun in a volatile situation creates a dangerous opportunity for violence and, yes, even death. A devastating outcome for families and communities, as you've heard here today. I find it incredibly offensive that speakers here today would equate the inconvenience of having a firearm temporarily removed with full due process with the life-changing consequences of gun violence if a firearm is left in the hands of someone who clearly should not have a firearm. A person who displays warning signs that they're considering suicide or engaging in a violent act, but who is prohibited under current federal or state law to possess a firearm can buy and possess guns. We know that. The Extreme Risk Protection Order bill will fill this gap, protecting public safety and allowing people in crisis the chance to obtain the help they need. Senators, I urge you to move this bill forward to a full vote in the Senate. The voters have spoken. The legislation must become law in New Hampshire. Thank you.
Thank you very much for being here. Are there any questions for Ms. Hanson? Seeing none. Thank you for your testimony.
Thank you.
Our next speaker is Andrew Caldwell.
Hi, can you hear me?
Yep.
Hi, morning. Thank you for having me. I don't know if the Leatherbys are still on, but I just want to express my condolence to them because, you know, that's a terrible story and I feel very terribly to hear it. I'm here because I am fully in support of this measure and I hope you'll pass it. I understand gun ownership is a sensitive topic. My family has been in New Hampshire for about my entire adult life and you know, I understand that we have a responsibility to balance the issues here. And I'm weighing this measure as I see it today against, you know, the right and life and liberty of those on the receiving end in each direction. I weigh it against, you know, the populations affected, all the Americans in this state, versus the potential folks who might find themselves being constrained by the law. And most importantly here is that, you know, I'm weighing the finality of getting things wrong. And I think I agree with those who've said today that, you know, the temporary separation of an owner from their firearms is a smaller and, in my mind, less significant outcome than potentially getting it wrong in a situation where someone could find themselves on the receiving end of gun violence. And I think about folks who are subject to conditions around domestic violence and school shootings and suicide in particular. All three of those lead me to strong support of this bill. I think in the way it is structured today, I see it as very thoughtful. I think it provides sufficient recourse for the folks who might find themselves being constrained by it. And I sincerely hope you will pass it and bring it into law. And thank you for having me today.
Thank you for being here. Are there questions? Thank you for your testimony.
Let's see. Next speaker is Brad Rodenberg.
Thank you. Brad Rodenberg in Meredith. You're one of the few people who's ever pronounced my name correctly.
Welcome.
I am a retired Marine officer and federal law enforcement officer. I did not think I would live to see the day when New Hampshire would be considering no-knock warrantless searches and confiscations based on anonymous tips without any crime having been committed. Yet here we are. And it's being camouflaged as suicide prevention, as if jumping off a bridge would be better. Anyone who has gone through a contested divorce can imagine how this will be abused. Someone drops a dime on you and you find out about it when the police show up at your house. Then afterwards, you have the right to hire a lawyer and try to convince the judge who approved the order that he was wrong. Please oppose this. It is contrary to the most fundamental concepts of personal liberty. Thank you.
Thank you for your testimony. Are there questions? Seeing none, thank you for being here.
Our next speaker is, I believe, J.R. Houle. One moment.
Good morning, can you hear myself? Or good afternoon now. So I'm calling in as the secretary for the New Hampshire Firearms Coalition. We opposed to this bill, and we have opposed it both during the House testimony as well as now. And I want to speak to three things, one of which has been covered slightly, and that is the due process section. The proponents for this bill say there's plenty of due process. There's lots of due process. Due process, by definition, is where someone has a complaint. They go to the court. Okay. The person has done something wrong. They're convicted before property is stolen. This bill would fundamentally turn that on its head, and instead, someone gets their property taken, and they have to go plead with the court to get it back. As it's been pointed out, it violates numerous constitutional protections. Secondly, this bill would also fundamentally put minorities and low-income families at greater risk because having attorneys is an expensive proposition. So those without the means to hire attorneys are going to be disingenuously hurt by this legislation. I would ask that you would oppose this bill. We will be sending in written testimony against it. There is no reason to go forward. There are way too many unintended consequences as drafted currently. Please oppose it.
Thank you, Mr. Hall. And are there any questions? Seeing none. Thank you for being here.
Next speaker I have is Cindy White. Cindy?
Hi, can you hear me?
Yes.
I can. Okay, great. Thank you, Chairman Hennessy. My name is Cindy White. I'm a former New Hampshire Senior Assistant Attorney General and prosecutor. This ERPO law would fill in the gaps in the New Hampshire laws to provide a way to temporarily remove guns from people demonstrating dangerous behavior before it escalates into firearms, suicide, or violence. Dangerous behavior is often a sign of violence to come. Many people who commit violence against themselves and others show warning signs. 80% of people considering suicide show some sign of their intention, and people who threaten or talk about suicide are 30 times more likely to kill themselves. There's an FBI study that found that in the weeks before an attack, active shooters also displayed warning signs, including threats to harm others and acts of physical aggression. Polls show that ERPO laws are supported by a large majority of Americans, 80 to 89%. And to help demonstrate that broad support in New Hampshire, I created a grassroots petition that's been signed by more than 830 Granite Staters from 112 towns who support this bill and the other gun violence prevention bills passed this session. Representative Altschiller referred to that petition, which was provided to the House, and I have submitted some additional signatures that we got after that time. I'm going to address the due process protections, which has been raised. This bill affords extensive and significant due process protections. Keep in mind that this is a civil proceeding, not a criminal proceeding. So criminal procedural protections have no applicability here. This bill, first of all, contains provisions to help assure the reliability of information at the hearing. It limits those who may petition for an ERPO order. There are no anonymous sources here. Anyone that says that is just plain wrong under the bill. It's limited to family, household members, and intimate partners who can apply for an order because they are the ones most likely to have personal knowledge of any signs of dangerousness. The only others who may apply are law enforcement officers who are sworn peace officers trained to respond to and recognize dangerous situations. Another safeguard is that a petitioner has to file an affidavit swearing under oath to the specific facts. Petitioner must swear not only that the information in the petition is true, but also must swear that he or she understands that making a false statement will result in criminal prosecution. The bill criminalizes filing a petition with allegations known to be false or made with the intent to harass as a Class A misdemeanor. That is the most serious level of misdemeanor, and it can result in imprisonment. A petitioner who made a false material statement under oath can also be prosecuted for the felony of perjury. Due process safeguards are present in the rest of the process also. A temporary ex parte order can only be issued if a neutral and detached judge considers the evidence and makes a finding by a preponderance of the evidence that the respondent poses an immediate and significant risk of injuring
Senator
himself
Hennessy,
or others.
Senator Hennessy, that's been 3 minutes.
Okay, I want to make the point that this standard of proof, preponderance of the evidence, is the standard used in civil trials. It's higher than the probable cause standard required to arrest people. This means more proof is required under this bill to temporarily remove a person's guns than to take away his liberty. And there's an even higher standard of proof at the next stage, which is clear and convincing evidence. So there are plenty of procedural safeguards, overwhelming due process protections, and I would ask you to vote ought to pass on this bill.
Thank you very much for your testimony. Are there questions? Thank you for being here.
Let's see. Next speaker I have is, I believe it's Pamela Hansen. Give me 1 moment.
Am I audible to you?
We can hear you.
My name is Pam Hansen. I live in Grantham, New Hampshire. I add my voice to those who support HB 687, the Extreme Risk Protection Order Bill. I do not believe that the bill infringes on personal rights. Rather, it gives families one more tool to assist in preventing the suicide by gun of a loved one. If this legislation had been law 2 years ago, perhaps my friend's son, Aiden, would be alive. He ended his life in front of his father and brother using one of the 5 guns which he owned. I urge the committee to support the passing of this bill. Thank you.
Thank you very much for your testimony. Are there questions? Seeing none, thank you for being here.
Next speaker I have is Thomas Dawson.
Hello.
Welcome.
Hi. Thank you for having me here. All right. So my name is Thomas Dawson. I'm a resident of Plastow, New Hampshire. I'm an Eagle Scout and a former BSA range instructor as well. I'm here today to ask you to please oppose this bill. This is an infringement on personal and constitutional rights, and there's been a lot of talk here how it can't be used as an anonymous weapon against gun owners, except that it could. All an individual has to do is say that they feel threatened by an individual or a misconstrued action to be threatening, and that's all that's needed for an individual to have their gun rights taken away. We've heard here many times how New Hampshire has a 90% fatality by firearms. As an individual with a bachelor's in electrical engineering and a master's in mechanical engineering, I can tell you that electricity is even more fatal than firearms. Simple shock of high voltage can kill anyone outright. Meanwhile, firearms deals with placement of shots on a person. We've heard here many times how this could be up to 12 months of time that an individual could be kept from their firearms. And we've also heard how the impact of these civil claims could be enough to take away an individual's FFL or federal firearms license, which is what an individual needs to be running a gun shop. So how many business owners in New Hampshire could this law be used against for simple customer complaints? I here ask you today to please oppose this bill. Thank you very much.
Thank you for your testimony. Any questions? Seeing none, thank you for being here.
Our next speaker is Ted Maravelis. I think that's how you say his name. I don't see him in the attendees list. Ted, if you're calling him by phone, please raise your hand by pressing *9. Otherwise, we will come back to you. Next person I have is Liam Bellows. I'm not seeing Liam anywhere in the attendees list either. Liam, if you were calling in by phone, I ask that you please press *9 to raise your hand and we will come back to you. Next one is Ethan Jennings.
Howdy. Can you guys hear me?
Yep.
My name is Ethan Jennings. I am a resident of the city of Laconia. I am speaking out in opposition to this bill, one of my first ever attempts at any form of political activism. The nucleus of this bill is that it allows people, whether family or other law enforcement, to authorize the use of force by law enforcement to seize firearms from someone with no criminal proceedings or convictions whatsoever. The danger to this should be apparent to anyone who's read the news in the last few months. This bill is framed as a public safety bill. I'm not convinced that it will provide more safety than the danger that it so clearly represents to people like the man in Maryland who was shot. Residents of New Hampshire are freedom-loving residents of one of the safest states in the Union. This bill does nothing to really protect their safety. It only adds the danger of armed law enforcement coming to their homes under tips from those who may or may not have the best intentions. This also isolates those who enjoy firearms or are involved in shooting sports from their families who may not have the same views on the Second Amendment or who have just different political views in general. This provides a tool to destroy the lives of people who have done nothing wrong and have committed no crimes. Thank you for your time.
Thank you for your testimony. Are there questions? Seeing none, we will move forward.
Our next speaker is Barbara Preen. I hope I'm saying that correctly.
Can you hear me?
Yep, go ahead.
Hello?
Yes, go ahead.
Hello?
Barbara?
Go ahead.
Hello?
Barbara?
I unmuted myself.
We can hear you.
I don't know what to do. I'm talking. Can you hear me now?
Yes.
You can. Okay, great. Good afternoon. I guess I'm the first one to say that. Thank you very much for letting me speak today, and I appreciate in advance your listening to my concern. I submitted written testimony. I ask you to vote in support of the Extreme Risk Protective Order, HB 687. It will help save lives, help prevent suicide, help prevent a sad ending to a domestic violence incident, or help prevent a shooting in moments of crisis, which I will speak to. My father was a lifelong hunter and a gun owner. I grew up with guns in the home, and I actually went to firing ranges with my father, along with my siblings. But in my family, we had an incident in 2006, which resulted in my siblings and I removing a pistol from my father's possession and taking away the key to his gun safe to one of our homes. My father was in a crisis situation with his needs as a wheelchair-bound person being challenged by a recent devastating diagnosis of my mother having a debilitating brain syndrome, PSP. He was facing giving up everything to move into assisted living. This was a situation my parents had saved and planned to avoid at all costs. He was very depressed for weeks, and clearly had become irrational that night. When my husband and I arrived, my father was out of control. He was yelling about he would never allow a move to a nursing home. My mother was crying uncontrollably and continuously saying she was sorry about her diagnosis and ruining all their plans. The first thing I did was go to my father's bedroom and remove his loaded pistol from his nightstand. I gave it to my husband and sent it home with he and my sister after unloading it. and my brother took home the key to my father's safe. I spent the night. I didn't even think about whether, and I wasn't aware that removing my father's access to his guns was unlawful. To us, it was just common sense that night. Later on, after a few weeks, my father gave the pistol to my husband. He gave the hunting guns that were in the safe to my brother and my brother-in-law. Honestly, I don't know. I shudder to think what would have happened that night if my sister hadn't called us and my husband and I hadn't gotten there quickly. Honestly, I'd do it all over again. This bill is just common sense. Please support it. Thank you.
Thank you for your courage in testifying. And are there questions?
I can't hear you.
Can you hear me now?
Barbara?
Thank you for testifying.
I can't hear.
Moving on, our next speaker is Rebecca Hayes, but I am not seeing Rebecca in the attendees list. Rebecca, if you're dialing in by phone, please press *9 to virtually raise your hand and we will come back to you. Next person I have is Mary Crook, and I am not seeing her in the attendees list either. Mary, if you're calling in, please press *9 to raise your hand and we'll come back to you. Next person I have is, I believe, Erica Layton.
Welcome.
Thank you very much. I am Erica Leon from Derry, New Hampshire. I have a degree in economics from MIT and I was an analyst for over a decade, and now I'm home with my children. I'm speaking strongly in opposition to this bill. While there's numerous reasons to oppose this bill on its own merits, their ongoing rioting due to abuse of police authority should give this community some pause. There are some attempts, sorry about the baby. There are some attempts at safeguards in this bill, but it's ripe for abuse from angry roommates, rejected dating partners, partners looking to enhance divorce proceedings, and law enforcement officers with an axe to grind. This weaponizes police at a very time when there's significant efforts to defund police across the nation. If I ask that you kill this bill, not only is it a bad bill, it's bad optics. Do the New Hampshire Democrats really want to be the face of expanding aggressive policing powers now? Thank you.
Thank you for your testimony and your brevity. And are there questions? Seeing none, thank you for being here.
Erica, I hate to impose. Do you know if Michael Layton plans on testifying at all?
Yes, he does.
He does? Okay, all right,
Yes.
Thank you.
Thank you very much.
Yep. Next up is Michael Layton.
Hi, thank you very much, Senators. It's a treat. I'm in the office. I don't get to see my kids, but I got to hear them as my wife testified. With that, I appreciate your time today, and I will also be brief. At a time when racism has come back to the forefront of American news and politics, I wish to remind the committee that the roots of gun control, common sense gun control, are solidly racist. And nowhere is this better exemplified than by the words of Chief Justice Taney's majority opinion in the Dred Scott case. It's simply heinous if you haven't read it. That's the roots of gun control in this country. That said, I'm not just going to focus on gun control because this bill goes far beyond that, and other people have spoken far more eloquently than I have on the Second Amendment. And I think with the bills we've seen, Democrats have declared war not only in the Second Amendment in New Hampshire, but in the country as well. With that said, and to wit, I hope that people will still consider our New Hampshire articles, Bill of Rights, which is the first part. It's not amendments as it is in the US Constitution. 15, rights of the accused. 19, searches and seizures regulated. And then similarly in the US Constitution, amendments 4, 5, 6, and 8, as well as Amendment 14, which prohibits states from abridging the privileges and immunities granted to all the citizens of the country. With that said, I'm not going to plead to emotions here. I want to share with you a timeline, facts of which you may find alarming, and quite honestly, I hope you do, because I find them alarming and can't believe that we're here today. The New Hampshire Constitution was ratified in 1784. After that, the US Constitution was ratified in 1788, and importantly, the 14th Amendment was ratified in 1868, which was the same year Jim Crow laws, which were designed to deny Blacks freedom and which continue throughout today. And shockingly, with everything in the news, none of them are being repealed, including gun control. Then let me share with you, in 2012, I was dismayed, as I think everybody was in the New Hampshire House, when former and late Representative Steve Valancourt used the German equivalent words, which I will not use, of "yes, we can." They are so tied to the Nazi Party that using them is literally verboten. It's forbidden in German today. The following year, a man named Steve Halbrook, who's dedicated much of his professional career to researching all of the forms that guns are used in. Not people like to use the term gun violence, it's misleading. He wrote a book. This was a warning. The book he wrote was Gun Control and the Third Reich. This was a warning for the country. This was not supposed to be an instruction manual. And yet every time I see a bill come through the House, it looks like it's right out of that book. It is amazing. It's documented. It's easy to substantiate. Here we are in 2020, June 24. We're now listening to the advocates for this bill propose taking us back. I will wrap up here. The advocates of this bill are proposing taking us back to 1935, May 2nd, when the Gestapo was empowered with red flag laws by decree. If passing this by law rather than decree makes you better, I can't really tell you anything. Thank you for your time.
Thank you for your testimony. Are there questions? Seeing none, we will move on.
Thank you.
We're coming up to the end of our list. One of our last speakers is Aaron Greenlee.
Welcome.
Aaron, if you can hear us, please unmute yourself. I think we might come back to him. Next speaker is James Gaffney.
Welcome.
James, if you can unmute yourself. I am not getting him. We'll move on. Couple of hands raised. I will let this person in. Hello?
Hello, my name is James Gaffney. Can you hear me?
Yes.
Yes.
I raised my hand 4 times and nobody responded.
Oh, you're in now.
I'm obviously speaking against this bill. This bill is repugnant to the New Hampshire Constitution and the United States Constitutions. It is an attempt to use a civil process to deny someone of a fundamental, natural, constitutionally guaranteed right. It is repugnant to your oath of office. You can see that quite clearly in Article 90. Article 20 of the New Hampshire Constitution similarly guarantees someone a hearing. I'm sorry, let's see, Article 20 guarantees someone a jury trial in civil causes where there's an excess of $1,500 in private property involved, which clearly in virtually every case of a firearm confiscation, it would exceed that. You folks cannot pass this bill. It's a repugnant and a contradiction to your oath of office. Everywhere these bills have been passed, in every single state across the United States, they've been abused over and over and over to silence and punish their political enemies and to give family members standing somehow miraculously to violate a person's, private, constitutionally guaranteed rights is insane. Every day we see family members get in arguments over private properties, over wills, over the division of assets from a husband or wife or parent that's passed away, and these are abused on a regular basis. Similar to our domestic violence laws, which are abused on a regular basis. You can speak to any lawyer about this. Similarly, there are allegedly consequences for false depositions and accusations, but never, not once in the history of the state of New Hampshire has a person been brought up on charges for a false accusation. We know it happens all the time. You can talk to any family law lawyer, but there's no mechanism or will to prosecute these people. And yet you've introduced the same mechanism in this bill, and it's somehow expecting a different result. This bill does not provide any due process protection. It confiscates or enacts a punishment against a person prior to them being able to face their accuser and defend themselves in a court of law. In contradiction to all of the lies that you have heard representatives and people testify, there is no due process in this law.
That's been 3 minutes.
Thank you very much for your testimony. Are there questions? Seeing none. Thank you for being here.
Next speaker is Rita Matson.
Hi, I just want to go on record as being opposed to this bill. I don't have a lot to say but I'm a 5 foot tall woman who has a 6'2" ex-husband who has threatened me with getting my handguns confiscated. And it sounds like with this bill being passed, he can accuse me of whatever, and that could actually happen, and it's kind of frightening to me. So that's all. Thank you.
Thank you for your testimony. Any questions? Seeing none, we're ready for the next.
At this time, I'll read off the names of those who I called earlier, but we did not hear from. That's Daniel Stewart, Edward Morse, Jeff Hyatt, Gregory Smith, Ted Marvelius, Liam Bellows, Rebecca Hayes, Mary Crook, and Aaron Greenlee. If I called off any of your names, please raise your hand and indicate that you'd like to speak. Otherwise, the only other person I have slated to speak is Representative Deb Stevens has her hand up, and I think she might like to speak for a second time.
Okay.
Hear me?
Yep.
Hi, you can hear me?
Yes.
Hi, it's Deb Stevens from Nashua Ward 7. And I don't know the gentleman. I think it was Mr. Clegg, but I'm not positive, with the pro-gun group. He quoted me, and I'm glad I heard it because he misunderstood. The quote that he quoted me in regards to making his point about his concern that these laws would be pursued for political gain is not accurate. I did make that remark, but it was relative to the article that was attached to it, to that quote from me. And I very deliberately and specifically did not make a generic statement about the group that was cited for amassing weaponry and boldly declaring their intention. It's called the Boogaloo Boys, I think, today. But anyway, the article says civil war. And so that quote, minus the article, makes it appear that I am making a political statement about political unrest, basically. But those were the remarks specific to the article. And I believe probably Mr. Clegg didn't mean to be so misleading because it's circulating on social media minus the article. And I think that gives a very misleading understanding of what I am talking about. It appears that I am talking about Trump supporters, and I am not. The group that I was concerned about happened to be Trump supporters, but my point was these are unstable people who are boldly declaring their intention to harm others.
Okay. I'm sorry, we need to cut you off. We've.
Thank you, I'm done.
Okay, thank you. Are there any others who've called in?
At this time, I only see one other hand raised, and that's Representative Wendy Chase. I don't believe she spoke previously. I think she spoke on an earlier amendment to another bill, but that's at least where we are.
Okay, thank you.
Hi there, and thank you very much for letting me speak. You're correct, I did not speak on this bill. I'm Wendy Chase, representing Stratford County, District 18. I sit on the Judiciary Committee in the House. And I just wanted to end this with letting you know that the gap between the criminal protective order and the total deprivation of freedom from an involuntary commitment is where the people are lost forever. This bill was written to address the Fourth Amendment and the Second Amendment concerns. It follows constitutionally tested due process policy and is already in place here in New Hampshire, as outlined in Chapter 135-C, Chapter 137-B, and Chapter 633, semicolon 3. This is opening an avenue for relief for families who are blocked from getting help to prevent a tragedy they can see coming at them full speed. Thank you for letting me say that. And I also want to thank you for sitting here and listening to all of the testimony. I do hope you support this bill.
Thank you very much. Are there any questions? Seeing none, I would just like to reemphasize that we would like to hear anything new that we have not heard yet. And please, please be cognizant of how long we've had the hearing. Thank you very much.
This is the last person I have to speak, and that's Penny Dean.
Thank you.
Can you hear me?
Yes.
Oh, terrific. Thank you. And I will try and not make the last the worst. My name is Penny Dean. I'm an attorney from Concord, New Hampshire. And I can tell you that this bill just doesn't give process. When they talk about due process, it's an absolute nightmare. And the bottom line is when those people talk about it being an inconvenience for having your guns taken, it's not an inconvenience. It can be life-threatening. If a person knew which day they were going to get in an accident or get shot at or any such thing, they wouldn't go out that day, but they don't. And once your firearms are taken, getting them back can take weeks, if not months, and a lot of money. I have only seen in my entire legal career one person be prosecuted for making a false complaint against someone in a DVP or any type of situation like this. And it was a very famous case on the Seacoast. And so when people say, well, they're going to be charged with a Class A misdemeanor if they commit perjury, it just doesn't happen. It just never, ever, ever happens, sadly. And for anyone to say these are robust and comprehensive protections, I don't agree that there are at all. And I do believe that the poor and those without education are going to be the ones who suffer the most. They may only have a firearm or two, and if it's taken away, they can't afford to get it back and they can't afford to buy another one. So I'd respectfully ask this bill be ITL'd. I just don't think it provides even close to the amount of protections that people deserve.
Thank you very much. I'd like to also say that if anyone has further testimony, please submit it by email. We are not, I was my mistake in allowing a person to talk a second time, and I apologize. We're not going to be able to do that due to the time commitment. So is that the end of the testimony?
I believe so. Curtis Wright and Representative Altschul have raised their hands, but as you said, if they have any further testimony they'd like to give, they can always send an email to the committee with any written comments. The only other person who is a new testifier is Michael DeBito, I believe. Michael?
Good afternoon. Thank you. Can you hear me? Okay.
Yep.
I just wanted to say, you know, as far as the due process, well, I am opposed of this House bill. I want to say, as far as the due process, and some of the people who are in favor of this bill have stated, you know, it may only be family members, people in the household, or police officers. In today's climate, the political climate, where even just expressing your views as a Trump supporter, some people can take that as a threat to their own safety. I think that's a big problem. It's almost as if people will need to watch their free speech. A lot of some family members don't get along with each other. And we've seen a lot of overreaction from people. And it could be taken to extremes if, you know, someone falsely testifies, or, you know, they may truly feel unsafe, I suppose, you know, if you have different political opinions than them, even if your political opinions are not deemed unsafe. So I just would like to oppose, and thank you for hearing my testimony.
Okay, thank you for your testimony. And other questions? Seeing none. That is it?
That is it.
Okay, thank you. So we are going to close the hearing. Sorry. Something, no, we're going to close the hearing on House Bill 687 FN. And, uh-oh, did I do that wrong? Okay, Senator O'Day.
Madam Chair, can we take a short recess?
I was just going to say that I think we all need a short recess, particularly my friend, Senator, maybe already on recess. Not sure.
Yeah, I need to take a recess. My dogs are here telling me they want to go out. So.
Okay, so we will take, what, a 5-minute recess? 10 minutes? What do you want?
3.
3.
Yeah, just very, very quickly, because I know Senator Chanley and we have to get onto the task force call this afternoon as well. So
we'll take a 3-minute recess.
Okay.
Thank you.
Senator French, you looked a little different there for a second.
Strange people running around my house.
Oh, weird. Did you disclose that when we began the hearing, Senator?
I believe I did.
Oh, good.
Our 3 minutes are up. Is there, let's see, we have,
You know, they never listen.
no, they don't. What are we gonna do?
I don't know. Anya's back.
There she is. Oh, I have my mouth full.
Cameron's eating his cookies. Didn't bring me any.
It's actually potato salad, and I don't have any cookies right now.
Okay.
Cameron had made cookies, Senator. I'm sure he would have sent you a batch via the U.S. Postal Service.
Express.
Absolutely.
Cameron, Griffin is the one who's eating the cookies.
I literally just had two.
Sorry about my dog jumping into the picture.
I like that.
Oh no, he's such a big love bug. And he wants to, he's been sitting here the whole time. While I've been sitting here listening, and he was like, hey, please let me out. So
So the one thing about Zoom is that animals are allowed to participate.
Correct.
We want to see your pets.
We have 4 dogs. We have 4 dogs here right now. I don't think you want that.
They're both of them are outside. You only saw one of them, and with dog groomers being closed, they finally opened up, but it took about a month to get the appointment. So they're going tomorrow, and they'll get to be looking, pretty good tomorrow. Right now, they just look really kind of scruffy. So it's all good.
So with a little granola bar in my mouth, I would like to hear a motion about going into executive function. Executive. I'm a psychologist. Executive session.
So moved.
Second.
So I will go down the roll call. I'll just say all in favor. Senator Chanley? She said yes. Senator LeVay?
Yes.
Senator Carson?
Yes.
Senator French? And I say yes. So we are in executive session, not function. I need more executive function. And I'm ready to hear a motion on House Bill 1249.
I move on to pass on House Bill 1249.
Thank you. And I will second that. And now what I'd like to do is hear a motion. Now at this time, does it make sense to put the amendments together and vote on them as a whole, which would mean 1550 and 1566? And is that it?
Madam Chair, would that also include the suggestions made by Senator Feltes?
Yes. Good point. It would, yes.
Okay.
So
Now,
just to review before we make a motion, just to review what those changes and everything that would include. So as Senator Hennessy said, that would include Amendment 1550 and then Amendment 1566. The changes that Senator Feltes suggested during his testimony is removing the word witnessing and that was, let me just pull up the page number on that.
And just actually moving it to the next letter.
No, that was a different.
Okay, sorry.
No, it's okay. Let's see. So Senator Feltes wanted to remove the witnessing and
Why don't we do these separate?
for line 13. He wanted to get rid of the words witnessing and then on the second one is line 25 through 27, renumbering B, or relettering a new B and changing the current B to P, which is on pages, let's see, I believe it's
That
page
is page 4,
4.
line 25 through 28.
And then the last change was on line 30, removing an unnecessary comma as well, just beneath that.
Right.
So those were the 4 changes that Senator Feltes had suggested in his testimony.
Correct.
So
And
Madam Chair,
yes.
why don't we vote on the amendment separately?
Well, as you know, the Senator Feltus's amendment includes everything that's in the first amendment in 1515,
In 1249?
and then adds his part. No?
I'm not, hold on, let me double check that. I don't.
It has the interdisciplinary, it has the grand jury.
Because I thought that all Senator Feltes did was he took the amendment that you had, Senator Hennessy, and then added in the new paragraphs on uniform law on notarial acts, which is on page 4, beginning on line 15.
That's correct.
So they're basically the same. It's just Senator Feltus's amendment has the addition.
Got
So
you.
I don't even know if we need to take up your amendment.
Correct. That's true.
1550.
I will defer to those of you who know more about that. I would, they really are the same. Yeah, they're the same with that added. So we wouldn't, I don't think, Jenny, do we have to do both?
Nope, we don't have to. It seems to, as you said, Senator, the same language. So all we would have to do is pass 1566 as a committee amendment with the changes Senator Feltes suggested, if that's what the committee chooses to do.
Thank you, Senator Carson. I think that is exactly right. Thank you, Jenny.
Yeah. So
if
do you need a motion on that?
Need a motion.
I move ought to pass on amendment 1566S with the changes suggested by Senator Feltes.
Thank you. I will second that.
Second.
And so does Senator LeBake. That's good. Okay, so is there discussion? Senator LeBake?
I do.
Senator LeBake?
Yes, just to speak to the notary process, I think that's an important process, and thanks to having that in place, we're able to continue business with wills, with real estate transactions. So that has been a huge help. And to put that into statute, even for a temporary time, is a very good idea. And then on the courts, what's really important to remember is that during this time of COVID, we can't do business as usual. And whether it's our schools or our voting process or our court process, I think that we need to adjust so that we can still serve justice to people. So the amendment is temporary and it allows the necessary hearings that would be going on. So I fully support both, and I'm very happy that we can be flexible enough to still facilitate all of these transactions. So just wanted to say that.
Are there other comments?
Yep, I have just a quick comment, Madam Chair. I also think in the Commission on the Interdisciplinary Primary Care Workforce is very, the section beginning on page 1, 26 through 28, where it talks and it adds in the use of telehealth. I think that is critical because I think it's shown us just how important telehealth is during this COVID crisis, because so many people have taken advantage of telehealth, whether it is for mental health services, counseling, people meeting virtually with their physicians because you can't get in, or you're housebound. I mean, I just think that it is critical, and this is the organization or the commission that would do this work. And I think it's very important, and it's a very important part of any kind of after action report we might create when we take a look at what worked and what didn't work during the COVID crisis. So again, I think this is well worth supporting. Thank you.
Okay. Thank you. So we will, I'm hesitating because there's something that came up that I think we will have to address maybe as a floor amendment, but because I still haven't gotten an answer. But I wanted to tell you everyone that the marriage officiant bill that is, I think, probably going to die with other bills that it was tacked on to, which would allow, so you know, you may be seeing it tacked on in some way. It stands that the coalition could make, be the beneficiaries of $6,000 to $90,000, $60,000 to $90,000 based on that. And so I was trying to do that for the coalition. So you may, I'm not going to add it now, but I would really like you to be aware that I may try to see, and we'll be in touch about whether there's a way to add it at another point.
Madam Chair, did the House disallow it, or?
I think it was attached to another set of like 50 bills that.
Yeah, it was part of one of the omnibus bills, so
Right.
Which we passed. So is there a problem with the bill?
You did pass it?
Yeah, it was passed last week.
Okay.
It was one of the last bills that we did, the marriage officiant bill. It passed.
Oh, okay. I was told that it had, did it go to another place where it was?
Happy Land.
Anyway, what?
It went to Happy Land.
Went to Happy Land? I think it might have, but I
don't know if they're sent to the House for the House to take a look at them, but that was a House bill because that was Representative Cushing's bill that had already had a hearing in the House, and it came to us. So it was attached to one of the omnibus bills, and we all voted for it last week.
Apparently,
So
the House is going to non-concur.
Really? Okay.
So I just wanted you to have the heads up. We will.
Okay. All right.
With it right now. So we have a motion. Is there anybody else that would like to speak to the motion that we have in front of us? Okay, then we will take a roll call, and I apologize for the kerfluffle. I wanted you to know. So Senator Chandler.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator, what's your name again? French.
Yes.
And I will also vote yes. So we have now passed the amendment. And now what we need to do is pass the bill with the amendment, which means that I need a motion on House Bill 1240.
We already have a motion from
Oh, that's
Senator.
right, we do. So we just need to vote on the bill as amended. Sorry, it seems, I don't know if you've experienced this, it's been kind of a long morning.
Yeah.
So we'll go through the roll call unless there's any comment. Senator Chandler.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes. Senator
French.
Yes.
And I vote yes. Now we have passed House Bill 1249 as amended. And I will would like to recommend, if willing, that Senator French take that out, or would you prefer not to? We haven't asked you to recently.
Oh, Senator Carson would do a great job.
Okay, would Senator Carson be willing to take it out?
Sure.
Oh, you know what? I don't want to make anyone do something they don't want to do.
Oh, she'll
that's
do it.
fine. I mean, it's
thank
okay.
you. Okay, perfect. Thank you. Just wanted you to have a moment in the sunlight, Senator French.
I appreciate that.
Okay, so the next thing we're going to do is look for a motion on HB 687 FN.
Move ITL.
I
Is there-
will second.
Okay, is there further comment?
Madam Chair, I believe we had this bill last year. It came out of the committee 3-2. It passed the Senate, passed the House. It was vetoed by the governor. So I guess if people want to do that dance again, okay. But I don't think anybody's changed their mind about it at all. So we should just go right ahead and vote and just send it on its way.
Okay, I would, Senator Chanley would like to say something.
No, that's okay. I'm fine. I don't believe we covered this particular issue, but that's fine.
Yeah, it is obviously a change bill in some ways that are important to me, but are there any other comments? Okay, then we will do a roll call vote on ITL on House Bill 687 FN. Senator Chanley,
No.
Senator Levin,
No.
Senator Carson,
Yes.
Senator French,
Yes.
and I vote no. And I'd like to make a motion of ought to pass on House Bill 687 FN. Do I hear a second? Senator Chanley seconds. We'll go through the roll call. Senator Chanley.
Is there any discussion? Sorry, I think Senator
Oh,
LeVay.
I'm sorry. Is there any discussion?
Yes, I just wanted to note that during the hearing, we heard somebody say that the NRA did support this. And I was Googling the NRA and I found an article from January 18th, 2019 from the NRA Institute for Legislative Action. And there were 9 points that talked about the fact that they would not support this type of law unless it had these 9 points covered. And as I was listening to the testimony, reading the bill and looking at these 9 points, it seems like 80% of what the NRA Legislative Action Group was looking at is covered here. So I think that's a very important point. Making legislation is about compromise and negotiating, and not everybody gets everything that they want. But I think it's important that we work with this. It is not a political issue, it's public safety. So I just wanted to point that out and say that I'm going to support this bill.
Thank you. Is there any other discussion? Seeing none, I will call the roll on an ought to pass motion on House Bill 687 FN. Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
No.
Senator French.
No.
And I vote yes. So it is a vote of 3-2, and I will take it out. And all we need now is a motion to come out of executive function. And I think I know how Senator French is going to.
So moved.
Oh, thank you.
Second that.
Second that. Okay. Oh, we will go through the roll for our last Judiciary Committee. And before we do that, I just want to say thank you to all of you. As you know, I will not be around to be kicked around anymore. No, just kidding.
Yeah. We will miss you.
I am going on what I will call an extended recess. And so here goes the roll call. Thank you, Senator French. Senator Chanley.
Yes.
We're voting on, sorry, we're voting on going out of executive session.
Yeah.
Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator French.
Yes.
And I vote yes. I think we should probably go out of executive function. And thank you all for your remarkable work. We got through this without being here until dinner time. And we will see everybody on Monday.
Madam
Okay.
Chair, I just want to say
Thank you.
thank you. Thank you for your leadership. And this is not an easy committee, but you managed it with a smile and with grace, and we will miss you.
Thank you very much. I appreciate that. I will miss all of you as well.
Yeah, cheers.
Thanks for all your help. I know that I was new to this whole chairing thing, so I appreciate all the help I got. Okay.
Can I say one more thank you?
Yes.
To our team as well.
Yeah, that was what I was going to say next. Good.
Yes, you take it over.
Well, I was just going to say that we have the best
Cookie
team,
maker.
best staff. Sorry.
No, no.
I mean, it's just such a treat to look out at these faces and know that everybody has our backs. And thank you very, very much. Today, it's Sonia and Jenny, of course, and Griffin and Cam, and of course, Alan, and not seen on screen, including Sarah and Ava, who's been a huge help in previous hearings. And I'm sure I'm forgetting people, Trisha, all of the people who've made this happen, certainly Greg and everybody I've forgotten. I would not be good at a awards speech, but I should thank my husband and God. No, just sorry. And so thank you very, very much to all of you who made this so much easier. Many thanks. Anybody else?
Thank you, guys. Thank you, Senator.
Thank you. Everybody have a great break between now and whatever comes up next.
Take care.
Thank you.
Thank you.
Bye.